to order, please. The first item on the agenda is a Pledge of Allegiance. Please rise and recite with me. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. We will proceed now to item number 3 on the agenda, public comment. We've had 10 people sign up for public comment. Each will be given 3 minutes, and there will be a timer, and I will give you a 30-second notice and to wrap up your comments. And also, please direct all of your comments to the chair. And then also, if somebody has made the same comments that you, please try not to be repetitive and just concur with the other speakers. So first up, we have Joe Bergen from the town of Day. And please come to the podium up here.
Thank you, Mr. Chair. Joe Bergen from the town of Day. A few months ago, or a few months of gathering information and hearing from the local residents in southwestern Marathon County, the County Board of Supervisors and the Executive Committee faces a large decision. In the past few months, you've heard feedback of reasons why this is a good project. You've also heard why this project should not move forward. Today, this group will discuss with other communities how their process has worked out in regards to a JDA process. I cannot say this is the best way to move forward, but typically something like this will lean towards benefiting those who write the agreement. So make sure you are the ones designing the JDA and place safeguards in it for the county, if that is the direction you are moving. I have heard it mentioned from a member of the executive committee that a JDA would be good because it can fund projects within the local area without utilizing taxpayer money. Remember, a JDA should be focused on taking care of the affected area from the project in which state statutes do not cover, and then possible projects. Last, I would mention the big picture view of our nature setting. Today, when people are traveling east on Highway 29 back from Eau Claire or from other parts of western Wisconsin, you see Rib Mountain standing out, especially in the fall with its vibrant colors. What will it look like when turbines are in front of it? Now visualize the following. As you are visiting Rib Mountain, looking to the north, you see the urban sprawl of the Wausau area and beyond the fabulous Northwoods. As you proceed up the park and look out to the south, you see lush farmlands, fields full of crops, and farmsteads and family homes with woodlots full of wildlife and fall colors. Now picture that scene in a few years with large 680-foot towers throughout the area. Where you want to come to Rib Mountain and look at these towers, which will be almost as tall as Rib Mountain compared to the current view. The question is, how much loss of tourism dollars could be lost to the area? What will be the draw for the people to spend time on that beautiful area? So be careful going forward, because once you lose what you have in nature, you don't get it back. Thank you.
Thank you. Next, we have Dan Barth from Knowlton.
Thank you, Chair. Dan Barth from the town of Knowlton. I speak strongly in favor of commercial solar and wind energy in our county. I raised my first garden in 1974. That was in Portage County. And in those days, the first killing frost came pretty regularly the first weekend in September. Now, 40 years later, that first killing frost is coming here north of Portage County, where we live, the beginning of October for the most part. That's climate change. I don't care how you cut it, that's climate change. And it will only get worse. 40 years from now, I don't know what the world will be like for our children and grandchildren. I'm very much in favor of reducing our reliance on fossil fuels and moving to renewable energy. the folks from Alliant Energy are listening, I'd be happy to have a wind turbine on our little farm. A lot of important questions, though, are being asked by the people who live in the area. We attended the Environmental Resources Committee meeting where a lot of also important questions were being asked. To the best of my knowledge, this will be decided by the PSC. And the best way for the folks of Marathon County and for Marathon County to protect themselves is by entering into a really good joint agreement with Alliant Energy and making sure that all of the questions and all of the concerns are covered in that joint agreement. Thank you.
Thank you. Next, we have Kathy Conley Barth. Kathy, please.
Kathy Conley Barth, 206540 Rabick Lane, Mosney, Wisconsin.
Thank you. Go ahead, please.
I've been talking to a couple people next to me today, people who are opposed to this project, and I understand that there are some really serious concerns. I also have been following climate science for, I don't know, 20 years, I'm guessing. And that's what worries me. It's what can we do to do our part in the world for all of these, the droughts and the floods and the extreme storms that have hit us in Wisconsin lately. And we could go on. So we have to, I think we all have to do our parts. I really feel bad for those people who are, faced with it, between two different wildlife areas, and they're faced with large towers and worried that the wildlife won't be here anymore. That's, I really feel for them. And I wish we could all put our information in one big pot and then really look at it, because I feel like we have different information that comes to us. We take these things very seriously, and we need to share that information so we can come to something that, while it might not be perfect for everyone, at least we're doing our best and also doing our part in terms of climate. I'm not sure how much time I have left, but I have a couple of things.
A minute, a little better than a minute.
Okay. So I'm partly incorporating something I saw this morning, and this person was saying, science requires doubt, policies require honest trade-offs, and democracy requires accurate information. And doubt is not the same thing as assuming that uncertain outcomes will be benign. Renewable energy has been expanded around the world, bringing down costs and reducing greenhouse gases.
30 seconds.
People in governments, thank you, around the world have taken climate science seriously, and that has made an impact, more than we could have anticipated 20 years ago. But we have to call out the more sophisticated arguments that might use carefully selected truths to manufacture unjustified reassurance. I think the science tells us that unless we all do our parts, unless we reduce greenhouse gases, we're really facing some severe consequences. Thank you.
Thank you. Next, we have Mary Clues. Excuse me, Mary Clues, please.
Good day, Chairman Gibbs and respected supervisors. I'm here today, I'm Mary Clues, I live in Wausau, but I'm here to represent in two capacities. First, as a private citizen, I'm concerned that my elected representatives may be ready to give away what power they may have to watch over my tax dollars. Considering to not pursue a joint development agreement is fiscally irresponsible, in my view. If this body does not have the final say about a project, then why would we give away a chance to mitigate or improve on a project that may go ahead without the county? It feels, I think all of us can relate to the story of David and Goliath. Like these big powers are out there, we feel like tiny little people. Well, it feels though also the county isn't a really big player, and it feels like David, the county, preparing to engage Goliath and then asking to have both his hands tied behind his back. If this project goes through, where will the local taxpayers will be without a joint development agreement? Second, as a member of Wisconsin Farmers Union, I would like to direct you to a letter that was given to all of the Marathon County supervisors. The letter is from our Marathon County Chapter Board. A few things about Farmers Union. Education is a pillar of the organization, and Farmers Union has been doing educational sessions around the state about where local, especially rural residents have power in a complicated energy sector. Health of rural communities is a high priority for Farmers Union. None of us farms alone. Please consider the chapter board's input that giving power away does not protect our communities. Thank you.
Thank you. Next, we have Cindy Nielsen from Eau Plaine.
Thank you for letting me talk. My name is Cindy Nelson. I live in the township of Eau Plaine. I'm kind of disappointed in the route that the county is going with everything. I did print out your farmland preservation plan, and there's nothing in here referring to turbines, solar, or AI data centers. They are industrial, they are not agriculture, they don't do anything with agriculture. Right, as of 2022, there are 3,085 farms in the area, from chickens, hogs, pigs, cows, cattle. They are all gonna have consequences. You're gonna be putting the farmers out of business that have the cows, the milking cows, beef cattle, and the calves that are sold to other farms. They only live 2 to 3 years after the turbines are running, and all the other animals do have side effects. So we're not gonna have any farmers in Marathon County. I have now lived here for 1 year, and there are many, we are a huge farming community. It's everywhere. You are going to put this area out of business. It's not going to be known for agriculture anymore. It's going to be all industrial. And if you look at previous large projects that Marathon County has done, nothing has been great, especially what I hear from other neighbors. They talk about what's been going on over the years, and they are not happy with a lot. Also, we are not equipped for the turbines to run. They don't run on wind. They run on the grid. The grid is not set up in the area, in the county, to support the turbines, especially the 2 projects, not only Hub City Wind, but Stonemark. There is going to be a lot of construction going on. There's going to be a lot to get these things up and running. Do not sell your soul to the devil just for money. Nobody's going to get the money personally. It's going to be gone. Once you get it, it's gone. Every time you get a payment, it's going to be gone. Do something for the people of the community. And if you don't, the residents are going to remember, and they are going to not let you be voted in on your next term.
30 seconds.
So please think about this seriously. I have always felt that I have talked to deaf ears every time I've been up here. This is a serious matter, and it is going to affect everybody. And the next time I come up here and talk, if the turbines are built, the 3 that are planned around my house, and I have health issues, I will be here every time preaching to you about the consequences of wind turbines. Thank you.
Thank you. And next we have Mark Radke from the town of Eau Plaine.
Chairman. First off, it's my understanding that the power generated by these turbines is not even going to be intended for central Wisconsin. So could these towers be placed elsewhere? That's a question. The other item, and this is just as a reminder for everybody, I sat on the Alternate Energy Advisory Committee. I have attended the public forum, and I kept a close eye on the online survey and took it myself. And the overwhelming response to all three of those was people are not liking the idea of the JDA. And I'm here just to say that out loud, and hopefully everybody remembers that when they go into closed session to deliberate about it. Thank you.
Thank you. Next, we have James Yeatus from the town of Easton.
Good afternoon, Chairman and members of the Executive Committee. I'm sure you and all of you have heard about the card game Shit on Your Neighbor. Well, this concept is happening in real life and in real time with this Hub City Wind project in southwestern Marathon County. While it is inherently true that there are rights of private property and what you can and can't do on your own land, it is also true that your neighbor also has property rights. If one's rights adversely affects the others, then there's a problem. And this is typically where government and courts step in to decide on what to do and where this executive committee and the entire county board must take a stand. There has been hundreds of comments against this project with facts and testimony belying the adverse effects that these wind turbines will have on the entire community. For whose benefit exactly? Maybe the landowner, yes, but then what? A small pittance to the county and townships coffers besides? Weighing that against the environmental harm, health concerns relating to the constant noise and shadow flicker they create, the permanent destruction of our beautiful landscape and skyline, the plummeting land values and people's properties, and the permanent destruction of valuable, irreplaceable farmland. I mean, what could be better for Marathon County and its residents than that? Some people have addressed you in the past saying that this travesty to combating climate change and lower energy costs to save the world. Frankly, they have no clue what they are talking about. And these monstrosities are not going to be in their vicinity. So why would they care? One made the point that they have these in other states and they are okay with it. Well, the vast majority of them are located on shit land, miles and miles away from people and cities, which is definitely not the case here. It has been said numerous times that nothing can be done because the PSC, a three-person government bureaucracy that oversees anything that citizens, it oversees and can override anything that citizens and their actual elected government entities want. So why bother fight it? Well, I and many others say BS to that sentiment. If our county government can't stand up and fight for its citizens, then really, what is the use of our county government? I realize that this will take money and resources to fight this, and by private litigation and ordinances and such. But it is a fight worth fighting to save our land, dignity, and the autonomy of our self-governing body. Alliant Energy and these other energy companies don't give a rat's patootie about us or the damage they will do to rape the land.
30 seconds.
They can do however they can do whatever they can do to make a dollar and then charge us for it besides. They must be stopped. Our county board and mission statement says that this county wants to be the best and leader. So then let's do exactly that. Let's lead the fight to rein in these entities and bring the power back to the people. You all have a very important choice to make in very short order about what you will do. Stand with the citizens of your county and fight, or stand aside and be bullied by these outside entities.
Time.
Thank you.
Thank you. Next, we have Dean Beck, town of Easton.
Dean Beck, Town of Easton. Thank you, Mr. Chairman and committee. The wind turbines are not going to directly affect my community. But this joint development agreement, I've been studying up on the wind turbines. The utility payments that both the county and the towns will receive, this sounds like this is going to be 150 megawatt, which takes local jurisdiction away. Is the county and the towns going to be paid on what it produces or what it's projected to produce? Because wind turbines, after they are exposed to the bugs and everything, if the face of those wind blades get bug residue on them, the efficiency drops as much as 30%. So they need to basically be cleaned every year. I'm worried more about the effects of, there's rumors out there, there's surveys, what to do with this utility money. And I think, if anything, it should be put in an escrow for the landowners that are not part of it and any potential harm that's going to come to the community, and not be wasted on something else, because the people that are directly in the line of this should be the ones that can have compensation if things go wrong. So I'm here to just wish you guys would look at it. A joint development agreement can work, but the damage to the roads and stuff should all be taken care of with the state statutes that exist now, where you can receive 3 times what the damage is. Don't let them get away with just paying you a one-time fee. And they also are using an awful lot of fossil fuels to produce everything that goes into that wind turbine. It is not that environmentally sound. Thank you.
Thank you. Next, we have Wendy Rogalski, please, from the town of Green Valley.
She's on.
Wendy is online. Wendy, 3 minutes will be your time.
Thank you. Good afternoon. I wanted to address the closed session scheduled today concerning strategy for engagement with Alliant Energy regarding the Hub City Wind project. Understand there may be legitimate bargaining strategy that should not be revealed publicly. If Marathon County is actually negotiating, no one expects the county to put its line to Alliant. There's an important distinction between how the county negotiates and whether it should enter into those negotiations in the first place. That fundamental policy decision belongs in the open.
Hey, Wendy,
the materials before you today.
Wendy, can I interrupt you? Can you drop off and rejoin? We've got a very bad connection, and I'll give you your full 3 minutes back, but try to drop off and rejoin, because again, for some reason, we're getting a huge delay in in the communications.
Okay, what if I step outside here and hold on a second. I mean, can you hear me better now?
Yes, we can.
Okay, can I start over?
Go ahead, please. We'll give you the full 3 minutes starting.
Okay, thank you. I'd like to address the closed session scheduled today concerning strategy for engagement with Alliant Energy regarding the Hub City Wind project. I understand there may be legitimate bargaining strategy that should not be revealed publicly. If Marathon County is actually negotiating, no one expects the county to announce its bottom line to Alliant. But there is an important distinction between how the county negotiates and whether the county should enter into those negotiations in the first place. That fundamental policy decision belongs in the open. The materials before you today clearly steer this committee toward early negotiations and consideration of a joint development agreement. Intervention is repeatedly portrayed as expensive, difficult, and less effective, while JDAs are presented as the preferred tool. But before Marathon County travels down that road, the public deserves a much broader discussion. Where is the analysis of communities that chose not to enter JDAs? Where is the detailed examination of what authority a county may surrender, restrict, or contract away when it signs one? Where is the discussion of preserving zoning, health and safety ordinances, intervention before the PSC, comprehensive planning, litigation if necessary, and every other tool potentially available to protect residents? Even the counties included in your own research show why caution is necessary. Kenosha County essentially acknowledged that after entering its agreement, officials learned there were things they simply did not know enough to address beforehand. That should be a warning, not a reason to rush. Hub City Wind has not yet reached the formal PSC application stage. This is exactly the time for Marathon County to fully understand its options and establish its protections before negotiating them away. So I'm asking every member of this committee to make one commitment today. Do not make the fundamental decision to pursue a JDA with Alliant Energy behind closed doors. If confidential bargaining strategy truly requires a closed session, limit the discussion to that strategy. But whether Marathon County should authorize JDA negotiations at all, what tools must remain available, what authority must never be surrendered, and what safeguards must govern those negotiations should be openly discussed and openly voted upon. And when you return from closed session today, please don't simply announce that staff has been directed to begin negotiations. If such a motion is going to be made, the public deserves to hear the motion, hear the debate, and know exactly how every member of this committee votes. This project will affect Marathon County residents for decades. A decision this significant should begin with transparency, not behind closed doors. Thank you.
Thank you. Next, we have Nikki Cottrell from the town of Brighton.
I originally planned to use my time today to restate my opposition to a JDA. I'll just note the irony of looking to counties with wind projects elsewhere in the state that have come to fruition when our actual goal is to not end up like them. Look instead to places where the project ended before a single turbine went up, like Lebec County, Kansas, or Worth County, Iowa, for example. At nearly every meeting that I have attended, the opposition from communities directly affected has been overwhelming, while the few voices in favor have consistently come from outside of the impacted area. I understand why those same Wausau residents worry about data centers. Ironically, they identify it affecting their property values and neighborhoods. I just ask that the same consideration be extended to the rural communities where this project is actually proposed. It's easy to support something when you won't be the one living next to it for the rest of your life. Those of us who will be affected have spent months researching this. This isn't an abstract issue for us. It's our homes, our health, community, dreams, and everything that we've worked for. I work in mental health and substance abuse, and my profession has taught me how important it is for decision makers to listen closely to the people who will actually experience the consequences. That's what we're asking you to do. You don't have to accept everything we say, but please investigate these concerns with the same level of diligence you would if this project were in your own backyard, because for us it is. Understand that since a lot of what a developer wants from a county isn't legally required, it's requested, and the county can simply say no to all of it. A $20 billion energy company is only interested in what will benefit them anyway, JDA or not. Developers often ask local governments for a letter of support to include in their PSC application showing community backing. The county can just refuse to write one. But if you do choose to go against your constituents who have asked you for months to not enter into agreement, please be thoughtful about the language, specifically the risk of Alliant inserting a non-opposition clause that limits the county's ability to participate in the PSC process. Please apply for intervener status. If you do enter an agreement with Alliant, the clearest way to show that you still represent your constituents is to stay actively involved in the regulatory process, independently evaluating what Alliant submits and considering outside experts to check their work. I would also encourage considerations of hiring independent third-party evaluations to complete the evidence presented by Alliant with outside research. I've put together an evidence matrix, 30 potential challenges tied directly to Wisconsin's CPCN requirements and the PSC's wind filing rules, 15 flagged very high priority. It covers public interest in siting, environmental impacts, land use conflicts, alternative site analysis, turbine specifications, etc. These are exactly the areas where the county can ask questions and make sure that the record is complete. But before any of that, I'm still asking for a moratorium. What form that takes is up for you to determine. There are options, including road ordinance updates, non-metallic mining standards, and other legally defensible approaches. Yes, there may be a risk of litigation, but we are still early in the process to carefully consider those options so it doesn't have to be inevitable. Slow this down, investigate it thoroughly, make sure the people who will live with this project forever have been fully heard.
Thank you. That will now conclude our public comment period, and thank all of the individuals that commented. And we'll move on to item number 4, approval of the July 15th, 2026 Executive Committee meeting minutes. They were in your packet. What is your pleasure? Motion by Supervisor Robinson, second by Supervisor Marash. Any discussion on the minutes as presented? All right, seeing none, all those in favor of that motion to approve the minutes of the July 15th, 2026 Executive Committee meeting signify by saying aye. Aye. Opposed? Motion carried and is unanimous. Let's move on to item number 5, operational functions required by statute, ordinance, resolution, and/or policy. And under 5A, a discussion of possible action by exec, a discussion of the options regarding the Hub City Wind Project, including panel discussion with local municipal officials and experts. I'm going to turn the mic over to our CPZ Director, Lori Miskimmons, who was asked to do some research on some of the questions that the exec committee had at our last committee meeting, and also has reached out and brought in some individuals that will be able to help hopefully answer some of those questions. And so I'll turn it over at this point to Lori Miskimmons. Lori, please.
Thank you, Chair Gibbs. So yeah, at the last executive committee meeting, you did have several questions that you wanted staff to go back and research. In the packet today, we put together 2 memos on some of those questions. There were some other questions where we felt we could not find enough information to answer them for you, so we did invite some additional guests here today as well to help with answering those questions. But I will start with talking about the memos in the packet and then introduce who we have here today in the room as well as online who can answer some more questions for you all. So the first memo in your packet, starting on page 3, is a summary of some conversations we had with PSC staff to try and understand a little bit more about the intervention process. There are a lot of uncertainties when it comes to this intervention process, so staff was not always able to commit to an answer one way or another in terms of what we could expect in going through the process, but they did walk us through how a construction case review would work. They did confirm that they believe that the Hub City Wind Project will fall under a certificate of public convenience and necessity, excuse me. And under that, the process usually goes that there are public information meetings that are led by the applicant, and then they file a pre-application notice at least a minimum of 180 days prior to their full application filing if it's over 600 feet. And as we all know, that is what Alliant has done for this project. Then a minimum of 60 days prior to their application filing, we can expect that they should be submitting an engineering plan. And then finally, they will file their formal applicant proposal. Alliant has indicated that would probably come sometime later this year, but again, there was a minimum of 180 days from the time they put that pre-application notice that they could actually do that filing. Once they turn their application in, similar to how we do things in the county, the PSC will have to determine if the application is complete. So they have 30 days with which to make that completeness determination. If it is incomplete, they can send Alliant back to redo some things, and then they can refile. That 30-day clock would then restart. But once the application is determined to be complete, the PSC then has 180 days in which to make their decision on that application. They can ask for an additional 180-day extension, and they do commonly do that, but that's really the PSC who decides if they're going to extend another 180 days beyond that first 180 days to make the decision. But the staff at the PSC said it is pretty common that the commission will take that additional 180 days. Once they've determined the application is complete, also they send out a public notification to let nearby landowners, local officials, everyone know that this project is proceeding for review. They'll begin conducting scoping meetings and they'll determine the environmental review process. They will do that in conjunction with the DNR. And then the PSC will hold hearings and finally make their decision. We did ask a little bit more about how the intervention process works. So essentially, when they make that notice of proceeding, that public notification that the application is moving to review, we will receive a letter, and at that time, we will have 14 days in which to determine if we want to apply to be an intervener. The PSC did recommend that we could talk with our legal staff to determine there might be circumstances where we can make a case to file for intervention sooner than waiting for that 14-day window, but that would be something we'd have to talk with legal staff about. As interveners, we would determine what testimony and exhibits we want to bring forward, and the commission would then determine how they review that or if they consider it in making their determination. So there was no real guidance on what should be brought forward. Obviously, it should be in relation to what case we're making to intervene. And as interveners, we would have to be available for the party hearings. We are open to cross-examination, discovery, questions, and rebuttal. and everything we submit becomes part of that record for the basis of the PSC making their decision. There is something where you can apply for intervenor compensation. The PSC was not aware of any county ever doing that. There is statute that explains what makes you eligible for applying for that compensation. And in reading that, I think the biggest lift the county would have is we would need to prove financial hardship in order to qualify for that compensation. We did review lists online of people who have applied for the compensation. It does appear it's mostly nonprofits and things like that that have applied for it the last several years. And people asked for anywhere from several thousand to over $100,000 in compensation reimbursement. We also included the decision matrix that the PSC used in the recent Badger Hollow Wind Farm review, because this is one of the most recent cases that has gone before them that would be similar to what we would be looking at with the Hub City project. So we thought it was important just so that people could see what issues the PSC is considering when they're deciding on the issuing of the certificate. A big question we had for the PSC was the results of the intervention. Were they aware of anything where intervening had resulted in an applicant being completely denied? And the staff could not recall an instant where an applicant had been denied, but they were pretty sure there were instances where applications had to be resubmitted, like an applicant was told to come back and resubmit, but they weren't aware of any intervention process that resulted in a complete denial. And then they gave us additional information for us and the public on how to really track that whole application process, making sure that we can be in the know as possible and be ready to intervene should we choose to intervene. Our assessment of our conversations with the PSC and looking at the stuff online and just looking through everything is that we still believe that intervention is often being used following unsuccessful or unsatisfactory JDA negotiations, and that it seems in combination with talking with other communities in Wisconsin, it seems that JDAs continue to achieve comparable and stronger outcomes than intervention, and that intervention can be costly and time-consuming. We have invited some folks here today too who I think have a lot more experience with intervention than me or my staff do. So I think they can talk to you about that too. So we'll get to them in just a minute. But I did want to move on to the other memo next. So the other thing we did is we tried to contact as many counties as we could in the state of Wisconsin who have had recent large-scale wind and solar developments to try and understand what they pursued when they heard these projects were coming into their community. So we did make a list of everything we could find for all the projects in the state. We did have to narrow down somewhat because we didn't have time to call everyone. And so we did narrow down to ones that we thought had recently taken place or were in the process of taking place. We tried, there was a lot of solar projects, but we did keep those on the list because those are the ones that have been moving forward more recently, but we also talked to some counties that are working on wind development or have wind development in their county and working on JDAs. We did use consistent questions when we called them. We did try and reach both elected officials and staff in the counties because we wanted to get both perspectives. We were more successful in reaching staff, our counterparts. It was just easier to get a hold of them than to get a hold of the elected officials, but we were able to talk to a couple elected officials as well. So we ended up reaching staff or elected officials in Columbia County, Iowa County, Kenosha County, St. Croix, and the town of Saratoga in Wood County. From the interviews we conducted with them, we found that there was a widespread use of joint developer agreements. Most of them reiterated that our authority for local control in these projects is very limited, and that they found that as their communities went through this process, that using a joint developer agreement was their primary and best tool for how they could address local concerns, understanding that they weren't going to have any control over whether or not the project moved forward. A lot of them advised us or said that they learned from what they were doing that early negotiation was critical, and Most of them also noted that negotiation was favored over PSC intervention for the reasons we previously stated due to time and cost associated with intervention, and that intervention does not always result in the same type of mitigations and considerations that you might be able to get through a joint developer agreement. From talking with those counties, our assessment was that our recommendation would be that they engage early in the development process and that we begin as soon as we can in talking with developers about our concerns and their willingness to sit at the table and negotiate on those concerns. Certainly, it's up to you all as the executive committee if we would move forward with a JDA, but certainly at least sitting down at the table with a developer to talk about what might be possible would be our recommendation, and using some of the feedback we got through the Alternative Energy Committee would also be helpful in starting to have those conversations. So I think what I want to do is first invite Lorelei Fewer, who's online. She is with the town of Saratoga, and I would like to invite her to speak first. We invited her just so that we could get some other perspective from another community. We did try and get a couple other folks, but because of timing, not everyone could make it today. We did ask her to sort of come prepared to speak to her experience of what it was like working with a developer and the path her community went through. She is the town chair for the town of Saratoga, and she is also their zoning administrator. So Lorelei, are you online?
I am, thank you.
Okay, so we'll go ahead and turn it over to you if you want to share any thoughts about your community's process, why you chose what you did, the advantages, the disadvantages, and how that's working for you.
We have thank you, yes, I will. We have a kind of a unique circumstance here as we own the property that solar went on, and they purchased the property, so they are not leasing the property. Therefore, we have more control. We work very closely with our county and with the help of the attorneys from the county and working closely with the developer, we asked the developer to pay to have a developer's agreement brought up and made by an independent legal firm. And we hired a firm out of Madison who assisted us in the developer's agreement. We also asked the developer and the attorneys to come to our municipality and see our municipality and meet our people and look at our ordinances so they understood where we were coming from, and we had that consistency that we're all on the same page and we wanted to work together. We also are very closely working with our neighbors because they also are going through solar arrays, and they do not have the same circumstances that we do by having the developers own the property, and we realize that makes a very large difference. So we worked very closely with our JDA. We now have another solar array coming in, and we are working again closely with our developer in establishing a JDA. We also, at the end of the project, we asked to have a decommissioning plan, so we also developed that. At this point in time, we felt we had a lot of control. We felt that they were very workable for us. And we do understand that there is a compensation given in lieu of a tax revenue. The county receives about 2/3. We receive about 1/3. We have a 150 megawatt facility. We receive approximately $350,000 a year, which comes in shared revenues. The second one will be the same. It's based on how many megawatts was submitted to the PSC. We now, the first facility was built by Savion and is now owned by Alliant Energies. And we've always have looked at this as Alliant is a business. They are not in a business to compensate the people that they are getting their companies energy from or to. They are not in the business of providing a reduced cost of energy to the people. Even though they are located here, we look at it as being a business, and that's what they are in business for, is to make money. The second solar array we have coming in will be owned, the end owner will be We Energy. Now, behind these solar and behind, I believe, most energy facilities, there are battery storage facilities that scared us also. So we are addressing that at this time. And behind that is a larger transmission line. And we are also addressing that. Those are things that were our unknowns and still are. So we are researching those. It's not always what you know coming in, it's what you learn along the way. So we are looking at those things too, and we're crossing each bridge as we come to it. I'm not sure what more I can tell you unless you have questions.
Laura, this is Kurt Gibbs, the chair of the committee. One of the questions I have is, now that you've negotiated at least one agreement, and I understand, the nuanced is that the town owns the property that this one project is on. What would you do differently now after going through it? You mentioned you know what you know after the fact. What would you do differently, and what would you continue to do if you were to do it all over again? And since you're going to be going through another project, maybe that's pertinent here.
Sure. Let me clarify. The town does not own the land.
Oh.
The land is owned by the developer.
Okay.
It is not leased.
Okay.
It is not leased by. What we wish we would have known was the size of the battery storage and how dangerous it is. And also that the transmission lines would be enlarged and the easements would be enlarged and there would be larger lines run through our town. So I wish we would have known those three things. And with this developers agreement, we are creating an ordinance for utility battery storage, which is very hard to do because there's none out there that will hold up in the courts right now. The University of Madison is developing one, and we're watching that very closely. But we're a little more knowledgeable of what comes along with the solar. The wind here in Saratoga, we are right along the river. We have eagle's nests, and that is one thing that a solar or a wind farm cannot get near. So we are not worried about wind energy here, but that would be a concern to us also.
Okay. Any questions or we'll go on to the other presenters and then we'll open it up to all three from the committee for questions from all three. So, Lori, please.
So the other presenters we invited here today, Andy Phillips from Atoles Law, and I think Bill Omakin is online. He is with the UW Extension. He's a local government educator. One of the questions the executive posed to us last month had to do with understanding more about 66041. 1MA related to the health and safety regulations and what we could do as a county in terms of trying to put an ordinance in place. What types of things would we need to have in place to justify or uphold such a path? So we felt it was better to invite some people who had more expertise in answering this question than we did. So we posed some other questions to them as it relates to the health and safety statutes and moratoriums. And I think I will turn it over to Andy first and let him go ahead and speak.
Thank you, Mr. Chair, members of the committee. As mentioned by Lori, I'm Andy Phillips with Atoles Law. We serve as general counsel to the Counties Association. We've represented Marathon County in the past. We've represented several other counties around the state, including counties who are looking at negotiation or regulation of solar or wind projects and battery energy storage system projects. So the question about 66.0401 sub 1M it's a question that relates to the overall authority of a county to regulate large-scale and small-scale renewable energy projects. So we're talking about solar and we're talking about wind. It's important to understand that sometimes there are BESS, battery energy storage systems, attached to those projects, and those are treated as a component unit of those projects, whether we're talking about 66.0401 or we're talking about Public Service Commission jurisdiction under 196.491. I bring this up because 66.0411M does not differentiate between large scale or small scale. It applies to all projects. But 196.491 applies to large scale projects. 66.0411M says that we have the ability as a county to regulate any size project. But if we do so, we have to do it on a case-by-case basis. And that comes out of a case from 2009 called Ecker Brothers versus Calumet County. I was involved in submitting an amicus curiae friend of the court brief in that case on behalf of the Counties Association, defending Calumet County's position to say, as an ordinance, we can say that we have the ability to regulate in the interest of health, safety, and welfare. That's what the statute says. What the court said in the Ecker Brothers case is, I don't care if it's health, safety, and welfare, it has to be specific to a proposed development, meaning that it has to be treated case by case as a conditional use permit type regulation. Okay, so now we know that when it comes to regulation of a solar or a wind project, it has to be case by case based upon the unique features of a proposed development, which in zoning world, we deal with as a CUP type process. But then you look at 196.491 of the statutes, and that says for large scale projects that are going to have generation capacity of 100 megawatts or more, if the PSC issues a certificate of public convenience and necessity, that it doesn't matter what our local regulations say, the project can proceed based upon the issuance of that certificate. So 66.0401 says that we have the ability to regulate large scale and small scale, but 196.491 says when it comes to large scale, 100 megawatts or more, we have no authority to regulate because if PSC says the project should go forward, it goes forward. That's the challenge that we have as counties. Now, I will tell you that in 196.491, the statute provides an opportunity for PSC to look at local impacts, look at local land use plans, look at local comp plans, things of that nature. All it requires is that PSC consider it. It doesn't require that anybody get sign off from the county, sign off from a town, sign off from a city or village. It just requires that the PSC consider those things. And so when we look at the prospect of intervening in a PSC proceeding, when we look at the prospect of adopting an ordinance attempting to regulate, understand that that is not going to change the statute that says that PSC need only consider local land use plans, but then otherwise it has the ability to issue that certificate of public convenience and necessity. And so again, it puts counties in a very difficult position when it comes to, I'll use the word controlling, when a county attempts to control a development that is 100 megawatts or more if it's a wind or solar project. Now, we also have this concept of standalone BESS, a battery energy storage system that exists independent of any sort of wind or energy project. I know we're not talking about that today, but I want to make sure I'm abundantly clear. That standalone BESS, those projects are not regulated by PSC. That's our opinion. We don't think they're regulated by PSC. But if it is a component part of a wind project or a solar project, it is subject to PSC regulation, PSC jurisdiction. And so in our work with counties, and not worked for towns, cities, or villages, in our work with counties, we have found that the best way to address concerns surrounding decommissioning, concerns surrounding road and highway damage, concerns surrounding setbacks and so on, you address those through a joint development agreement because we don't have any authority to address those through ordinance. And so, again, we attempt to negotiate a favorable joint development agreement to address those particular concerns. I left out emergency response. That's also obviously a very important concern, both from a county and a town, city, village perspective. That's not to say that the counties we're working with are thrilled with that particular result because frankly, I think if you talk to a lot of our clients, they would say we would much rather have total control over the entire development process. That said, I think the clients that we work with would also tell you that they recognized the realities of how the statute works, recognize the realities associated with either intervening with the PSC process or attempting to otherwise litigate a stop or a shutdown of the project, and said, let's do what we can to ensure the taxpayers and the citizens within our county are protected to the extent they can be. That was their opinion, and that's why they authorized us to again negotiate the joint development agreements. And so I don't know if Mr. Omican, who I've spoken with several times about this topic, he has a wealth of knowledge on this, if he has further insight on that, because I know he's worked with other local units of government than just counties. So he might have some different perspective, but from a county perspective, that's typically what we're looking at, not only as WCA, the Counties Association, but also the other counties that we represent.
I would agree.
Bill, would you like to?
Yeah, I wasn't sure if I should just jump in. Good afternoon, everyone. I'm Bill Omican. I'm a professor of local government law at UW-Madison Division of Extension. And I've been working on this issue around the state of Wisconsin. As Andy Phillips said, I work with counties, cities, villages, and towns. I've worked with a lot of folks who are opposed to these projects. I've worked with developers, and so I've worked with the gamut of stakeholders. And I agree with absolutely everything that Attorney Phillips said. He's correct on the law. He's correct on the court cases or the common law that comes out of those courts. The little bit additional information I would give is that the legislature a number of years ago made it very clear that the state was committed to renewable energy, and that's in part why they adopted statute section 66.0401. So there is a clear intent by the Wisconsin legislature to move forward renewable energy projects. It's probably no surprise to any of you as county board members, and I served a number of years on a county board, so thank you for your service as supervisors. But it's probably not a surprise that the legislature, to further that, took away, as you understand it, some local government authority in this area. There have been efforts in the Wisconsin legislature to restore some of that authority. There were bills in this last session which ended up dying because they did not make it through both the Senate and the state assembly. But the legislature wanted to encourage these projects, and they believed at the time, going through the legislative history, that the best way to do that was to, for the most part, preempt local units of government on those projects 100 megawatts or more. As Attorney Phillips also said, for projects under 100 megawatts, local units of government retain some limited authority, and that's the area where I've particularly been providing guidance to counties, cities, villages, and towns. I've written a model ordinance to help local governments determine what level of regulation they want to have. I've written also a guidance document to local units of government on how to deal with renewable energy issues across the state. And I will note that I office in Dodgeville, Wisconsin. I'm only a few miles from the Badger Hollow wind farm. So pretty aware of the controversies that this can create. A final comment I will make is just the way Wisconsin law is also structured is that unlike cities and villages, counties and towns in the state of Wisconsin are only limited to those authorities provided by state law, administrative home rule. Cities and villages can go a bit beyond state law, but counties and towns cannot. Don't shoot the messenger here. That's the way the legislature intended it, it's the way they wrote it, and that just happens to be the reality. And the only way you can change that, in the same way that the only way you can change 66.041 is to go to the legislature and seek legislative changes and get the governor to agree to that. Going to the health and safety provisions, Attorney Phillips did a great job of outlining the importance of that provision, but also the limitation of that provisions. When we're at a 100 megawatt project like you are discussing that you're considering as a county board, it's all under the PSC's jurisdiction and the CPCN, Certificate of Public Convenience and Necessity project. And as we have recommended as the University of Wisconsin, if the local unit of government still wants to have some tools, there's really only two tools that are available. and Attorney Phillips mentioned that, and I'll finish here in about 20 seconds. One is to update your comprehensive plan to address renewable energy. And as he said, the Public Service Commission has the obligation to at least review that, but it doesn't mean that they have to follow that. I asked the Public Service Commission staff if the PSC has ever reviewed a comprehensive plan with whether it's solar or wind or some other types of things too. We get into cell towers and all of that. But they said that there is no case that they could remember where the Public Service Commission denied a project because there was a concern that the project was not consistent with that comprehensive plan. So knowing that, then what is really the only effective tool you have left? That's the joint developers agreement, and that is a contract. That is a contract under common law, so court-made law, not so much by the legislature, and that allows you to put into place provisions that you would not otherwise get because the legislature has limited your authority. That's why local units of government are looking to joint developer agreements, JDAs, as an opportunity to try to gain some tools, some regulatory tools, so to speak, that they otherwise would not have. So I just wanted to give you kind of that overall perspective of what the legal and regulatory and to some degree political structure is in the state of Wisconsin. And it's a hard message. I get to go to lots of communities and to the county board, the city council, the village board of trustees, or the town board and say, your tools are really limited, and they're limited on purpose by the Wisconsin legislature, and the only one that can give you additional authority is the state legislature. So with that, I will stop, and I know that Attorney Phillips and I welcome your additional questions.
So I'll now then open it up for discussion from the executive committee on the question, discussion and options regarding the Hub City Wind Project, including panel discussion and questions for any of the panelists. Supervisor Robinson, please.
So in the past, we've had some discussion relative to moratoriums. I'd just like to, if we could go back and revisit how moratoriums have been used, if they've been used, and what the effectiveness has been while we would, for instance, review our comprehensive plan. If you could comment on that, or either or both of the attorneys.
I can start on that, and I would defer to Corporation Counsel Desmond as to how a moratorium may have been used in Marathon County zoning previously. But overall, when it comes to county authority to adopt a moratorium that would essentially halt a development, we've said that a moratorium, as long as it's adopted as an ordinance under 59.69, that's the statute that authorizes zoning, that a moratorium is legally defensible, although I will tell you it's not entirely clear as to what purposes. What is the list of purposes that you can utilize for a moratorium? The reason I say that is that there is a provision, I think it's in I'll let Mr. Omican correct me when I'm wrong, 66.1002, I believe, that limits the authority of a city or village to adopt a moratorium when it comes to certain development activities. Counties are not included within that statute. And so, at least as it relates to city and village zoning authority to adopt a moratorium, it's a bit more clear as to what is subject to a moratorium and what is not subject to a moratorium. But regardless of the underlying authority to adopt a moratorium, if we have that authority as counties, it is going to be a limited authority, because it is clear based upon statute and case law that a moratorium can be implemented for the purpose of allowing a municipal entity, including a county, to develop a more comprehensive set of regulations dealing with a particular land use. It is not a moratorium to stop development 100%. That would not be upheld by a court. And so I know that, and I hate to use the D word here, but data centers, those have been subject to moratoria all over the state. I have seen moratoria that have been implemented that I have questions concerning the legal enforceability. You get out 2 years, 3 years, that to me looks more like a stop than it does a pause. I've seen other moratoria that are 6 months in duration, and immediately upon adoption of that moratorium, the county or city or village undertakes a significant effort to develop a regulation. To me, that is a lot more legally defensible. And so, again, I can't give you a bright line rule as to when a moratorium is going to be defensible or not defensible, other than to say that the longer it is and the more it looks like delay as opposed to pause, the more defensible it's going to be.
Bill, anything to add?
Yeah, I would just say that I agree with that 100%. In the Calumet County case, the Ecker Brothers case that Attorney Phillips mentioned, there was some indication that the county board was trying to block the wind project, wasn't trying to go forward and develop a comprehensive set of regulations to address it in a short time period. And that appeared to be one of the factors that the Court of Appeals was weighing when they decided to rule in favor of the wind, the farmers who own the land upon which the wind project was going to be developed. So there's not a lot of guidance out there in the case law, but our best advice, similar to what Attorney Phillips said, is if you're going to adopt a short duration moratorium of a year, possibly 18 months, and as long as you're showing that you are actively working towards adopting some type of regulation consistent with your zoning authority, that's more likely to be upheld by the court. But if it's clear that the intent is just to block the project, remember, we have the statute that Attorney Phillips cited earlier that says that there is the intent by the legislature to promote renewable energy, and it's going to conflict with that and likely then to be overturned by the courts.
Just a follow-up to that question. So in Marathon County's case, where we do have a large scale ordinance on wind projects, and we're actually looking at a modification that's coming to the board this month, can you speak to the efficacy of a potential moratorium with a set of rules that already are in place or ordinance that's in place currently?
When we think about what a moratorium does, I'll address this briefly. When we think about what a moratorium does, it essentially freezes legal rights and obligations at that moment of time when the moratorium is adopted. So that, and this happens, there is sometimes a race to the zoning office to get a permit application on file so that the developer can proceed under the quote-unquote old law as opposed to new law. So if the purpose of that moratorium is to press pause while we wait for adoption of the updated or amended regulation, I think that is defensible. Again, we have concerns about not the legality, but the enforceability of a large-scale ordinance because we have preemption in 196.491. But that aside, if we are looking at pressing pause to allow for the updated or amended ordinance to come into play, you could certainly do that. And as I understand it, the updated ordinance applying to large scale would enhance the notice features associated with these large scale projects for the purpose of informing the county to determine what is our course of action going to be with the PSC, if I understand that updated regulation.
I think that's pretty accurate.
And Mr. Chair, if I can just jump in, I agree with everything that Attorney Phillips said. Yeah, I would just note that in the model ordinance that we wrote for counties, the university wrote for county, cities, villages, and towns, we do address above 100 megawatts. And as Attorney Phillips said, it's information-based because you can't put in any other kind of regulations. And so it's to make sure that the local unit of government has all the information in a timely manner so that it can determine how to react.
Okay. Other questions? Open it up to the rest of the exec committee. Okay, we got Supervisor Hoppe, please.
I have a what-if question. We're going to be getting a new governor soon, and I know that this PSC has been selected by Governor Evers. So what happens if the new governor selects a new commission and they have totally different views? Where does that put anything?
I think that's a great question. I don't have the roster in front of me, but I believe the first time a commissioner is up for appointment is 29.
Right. That's correct.
3 years we've got with the current commission. So nothing is going to change in terms of commission philosophy, at least for 3 years. That said, if it's Governor Tiffany, I think that he's made himself clear on some of these issues in terms of his views. I don't know if it's Governor Crowley, if he's made his views clear. The one constant that we can count on, I think, from the state is change. I think those views will change. I don't know if that will be good, bad, or indifferent for county government. It's too early to tell. I just don't know.
Very good, thank you.
I would just add.
Go ahead, Bill.
Yeah, I would just add that we will have a new legislature convening in January of 2027. They could, as I've said before, decide to modify 66.0401. Again, there was legislation in this last session sponsored by Senator Howard Markline, actually my state senator down Southwest Wisconsin, to provide enhanced or return some of, perhaps a better way to say it, return some of the local government control over these projects. But again, it did not get all the way through the legislature, so it's not law. I'm sure there'll be an attempt to try to move forward similar legislation in the next session. Whether or not it passed, I can't predict because I can't tell you who will be sitting in what seats in January 2027 at the state capitol.
Okay, other questions? Other questions? Supervisor Dickinson, please.
Thank you, Mr. Chair. So I have two questions. One is, I've heard that under the state statutes, that there are penalties if these developers damage roads or the environment, et cetera, and that JDAs, in a sense, aren't necessary to handle those particular issues. So I'm asking, is that accurate? Are there already penalties under the law for what developers might do?
From my perspective in dealing with county government, I don't know that I would rely on the Public Service Commission to enforce the CPCN standards as it relates to road repair. I would much prefer to have the authority as a county to address that issue through a joint development agreement. And if we don't have an agreement, I think it's 86.02 and 86.14 are the statutes that allow us to assess treble damages for road repair. Now, the problem I've got with 8602 and 8614 is that it's retrospective in its application. We have to have damage occur before we assess treble damages and try to hold them responsible. So my preference, my strong preference would be to address road repair up front so that we get the roads into a condition during the development where they don't need constant repair and I have to keep sending bills. So that's why I think a joint development agreement is many times beneficial so we can address those issues in advance.
My second question is, are there examples of developers paying out damages in a JDA in these examples or other examples when it comes to wind or solar? Or are there examples of them reneging on a JDA and saying, I'm not going to pay, we didn't do that, take us to court?
That's a great question. I can only speak from my own experience as our firm has negotiated these JDAs. We've negotiated allocation of responsibility for damages to certain highways along planned routes for the development and construction of a particular project. It's not unique to solar or wind projects. For example, in the large data center project in Port Washington, Wisconsin, the Vantage Data Center, there is in that agreement itself, that's a development agreement between the data center developer and the city of Port Washington about responsibility for damage to roads. I've not heard of a developer reneging on that. I take that back. When we had frac sand mining back in, I'm going back 20 years, we've had developers that have gone out of business. So when we say reneging, they've gone out of business and that's created problems. But I've not recently had any developer on a solar or wind project renege on their responsibility for road repairs. Not to say it wouldn't happen, but I'm just not aware of it happening.
Yeah, I'm not aware of one either, and I've looked at a lot of JDAs and I've talked to a lot of local units of government. I have not heard of a local unit government being concerned that a developer hasn't complied with the terms of the JDA.
Okay, Supervisor Lemmer, please.
Thank you. Just piggybacking, how do you say that? Anyway, off of that, are there protections we should be thinking about putting into a JDA to prevent somebody from going out of business?
That's another great question, because what typically happens in these developments, and I say typically understanding that these are relatively recent or new developments, these large-scale solar and wind projects. What typically happens is developer will sell their completed project to a utility because a regulated utility is better able to utilize what the project's intended purpose is. And so when you have a transfer of ownership interest in developer or transfer the entire project from owner A to owner B, you of course want to address that in the JDA to make sure that successor owner is going to be, number one, acceptable to county, all right? And number two, is going to assume all of the obligations of the JDA. Because frankly, if current developer sells the project to Andy Phillips, hate to tell everybody, doesn't have the financial wherewithal to meet all the obligations in that JDA. And the county's going to say, you know what, no, it's not okay that Andy Phillips assume those obligations. But if, for example, We Energies were to purchase a project, We Energies has all sorts of financial ability to fulfill on the promises in the JDA. And so the county's going to say, I'm comfortable with it, as long as We Energies promises to fulfill all of those promises within the original JDA. So yes, that is definitely something we want to address in the context of a contract.
Is there also the ability for requiring bonding and other various financial assurities for performance?
Yeah, and let me talk about wind and solar in particular, is that we're concerned about decommissioning. Once the project has hit its useful life, we don't want developer or owner to simply leave and say, you guys get to deal with taking the turbines down, you guys get to deal with taking the panels down. And so much like we did back in the 2000s, early 2000s with frac sand mines, is that there ought to be a decommissioning plan. And that's part of what's submitted to the PSC as part of the CPCN application. But then we want financial assurance that you're going to be able to carry through on that decommissioning plan. I'm less concerned about a regulated utility like We Energies following through, because they're a regulated utility. But for developer, I want to see a bond or something financially supporting that decommissioning obligation. I'm going to say this right here, is that it would be really nice if we had a counterpart to NR 135 on the books. NR 135 is the quote-unquote decommissioning, it's called reclamation, but that's what we deal with mining, is that there has to be a reclamation plan, and the administrative code addresses the fundamental elements and financial assurances associated with reclamation. I wish we had administrative code provision that dealt with the same thing for solar and wind projects. We don't, so we build it out in the JDA, and we insist on financial assurance for that decommissioning.
And I would just add, Mr. Chair, in both the guidance document and the model ordinance, we make very clear that local units of government should consider some type of financial assurance. So this is something we absolutely recommend as the University of Wisconsin. Make sure you have that protection, because one of the questions we get a lot is bankruptcy. What happens if the firm goes bankrupt? They haven't been able to sell the project to a regulated utility, and you want to make sure that letter of credit or bond is still there.
Okay, thank you. Other questions? Supervisor Hoppe, please.
I have either heard or read that the energy produced in these wind turbine projects, the energy does not go back to the people that live there. It goes off to the grid someplace else. Why? You know what? It's like, okay, I had to give up my farm and my livelihood and everything else so that all this energy can be produced to go someplace else. You know, so what about the families? What about the businesses that are lost, the animals that die? And then my second question is, in a JDA, is there any kind of a clause or anything about they will pay for medical treatments for the damage that the wind turbines cause in people's health?
I think those are valid concerns. And from my perspective as a lawyer representing county government, I'm very careful to ensure that whatever we address in a JDA or an ordinance or regulation is within a county's authority. We as counties don't regulate energy utilization. We don't regulate where energy goes. We don't regulate the grid. We may have a voice in that process through the PSC, and that's fine, but we don't ultimately regulate that, so we can't address that, in my opinion, in a JDA. We also don't represent the interests of impacted landowners, whether it be their families, their livestock, their property values. We don't regulate that. We don't have the same interest as those landowners have. And so we would very much, as county government, encourage a responsible developer to address and mitigate those impacts. But when it comes to any sort of agreement that relates to those impacts, that, in my opinion, ought to be between landowner and the developer, not in a county JDA.
And Mr. Chair, if it'd be okay, the only thing I would add on to that is the Public Service Commission does have stray voltage provisions. And so stray voltage has to, in many cases, be a part of the study that's done, the impact on livestock. We've got 1.2 million dairy cows in the state of Wisconsin, so that's a significant concern. And so I included a provision in the model ordinance also relating to stray voltage. But there's nothing on human health at this point.
Okay, thank you. Supervisor Dickinson, please.
Thank you, Mr. Chair. So Alliant does not have to agree to any JDA. Is that correct?
That's correct. There's
Okay.
no law in place that says they have to. I think that's your point.
So we've heard from the developer in this situation a lot of shiny, beautiful things that can come from this development. When asked questions of the concerns of the water, the land, the amount of roads, the environment, the birds, the people's safety, et cetera, I don't, and correct me if I'm wrong, I don't recall one time the developer really saying, yeah, that's a concern, and actually kind of stand up and say, we understand those are concerns and we would love to address those. So I would then ask, why on earth would a company, a developer that doesn't have to enter into a contract and doesn't acknowledge the risks want to get into a JDA when there's no benefit in them for it? To me, it seems like a way to say, we want to buy you off. We want to give you something back because we can do what we want to do, but we want it to look good. We want kind of a PR win that, hey, you know what, we helped with your, in the one case, you know, with the fire station or with the well, you know, so it gives them, you know, we did something nice. So it's a broad question because I mean, if I'm a strong businessman, why would I give my money away? Thank you.
Again, I think those are valid concerns, and I think those are valid questions. And I'm not going to offer opinion on what may or may not be a developer's motivations. What I will say again is, as a lawyer representing counties, is if you look at the statute, and this is well laid out in Miskimmins, is that how you pronounce it, Lori? Ms. Miskimmins, there's a tongue twister. In her materials, if you look at page 3 of her memo that is dated August 6, summary of PSC research on intervention. The decision matrix that she's replicated from the Badger Hollow project, it has 11 issues that are in the bullet points. Those 11 issues are not made up by PSC. They're not things that they consider because they thought they should. That's what the statute has. And so in theory, the Public Service Commission is supposed to consider those things in the application for the Certificate of Public Convenience and Necessity. Whether they do or not, that's up for debate, but they're supposed to consider all of those things. What the Joint Development Agreement does is it allows the developer go to PSC, and I'm looking in particular at issue number 3 that Lori's identified on this bullet list. If approved, would the proposed project comply with 3D6 of the statute and not unreasonably interfere with the orderly land use and development plans for the area involved? If they have a signed JDA with the county, they can go to the PSC and say, check that box, we've done it. That's what it allows them to do. Again, whether that's good or bad, that's up for debate, but that's why I believe a developer would want a JDA, is so that they can say to the PSC, we've addressed that element. The other elements, those are things that are outside, again, a county's authority. But in theory, the PSC is to consider those things in the application for the permit.
So I'll just make a comment. So really, it's what's in their best interest. Thank you.
Other discussion? Other questions? Supervisor Gao, please.
Thank you, Mr. Chair. I have a couple questions. First of all, we've been told by staff, it's that other people say get into it early for JDA. Do it quicker, do a process. What is your experience in having, what timeline have you been with other counties? That's my first question. And going through a JDA for a Pacific County, how much time does that take until you finally come to agreement? It may vary, I think.
It varies, and we're talking about months of negotiation because you've got to understand that we're not negotiating where we sit in a room for a week and go at it back and forth with these things. There are all sorts of things that are going on with the permit application, so oftentimes you have a lot of lag time between one set of proposals and comments on those proposals. What I would like to see in a perfect world is to have an understanding between industry, that includes developers, utilities, and everybody, as to what counties want to see in a JDA. What do we want to see addressed? So that when I or somebody else sends on behalf of a county a draft JDA, they know what to expect in there, and they agree that this is a reasonable set of topics to address within the JDA. I want to shorten that negotiation time. There's no reason that we have to have lawyers going back and forth on issues that, in my mind, are very reasonable to address. All right, we're not looking to make money for the county. We're looking to protect as much as possible the taxpayers and citizens of a county. And so we want to address those things, and I'd love to see the industry recognize those issues to shorten that negotiation period. So it's a very long-winded way of saying it depends.
Okay, in your experience, you've done a couple of these JDAs. Then what is the experience you've seen? What's the shortest and what's the longest months that you've gone through?
I've got two that are still pending because for one reason or another, I don't know exactly the motivations. I have my suspicions. They have pumped the brakes on finalizing the JDA. I think.
The developer.
Again, yes. And because, again, this is a very important point. Once a CPCN is issued, we have a statute on the books that says you can go ahead with a project no matter what the local government says. All right? So we're trying to obtain, if you will, leverage points with developer to try to finalize the JDA. Others, a period of 6 months and it's done. And we get it done.
3 to 6 months?
3 to 6 months, we can get it. I could get it done in 3 days if people are reasonable, but it's 3 to 6 months.
Second question?
Go ahead, please.
Thank you, Chair. Has there been a case that you've been working on where the actual went through a JDA process and it just didn't work out for the Pacific County that you've had?
Yes.
And then has that county gone looking at doing an intervening process?
They're considering it. They've not actually done it, but they're considering it because with an existing permit application, we've had developers say we're not interested in negotiating any further on the JDA, so that's forced the county's hand as to what's our next step. In 2 instances, we've had to file an appeal on the permit application because our claim is that the PSC did not adequately consider all of the interests that are delineated in statute that they have to consider. So yes, we've done that.
Okay, thank you very much. Appreciate your answers.
Supervisor Mask, please.
Thank you, Chair. One of my concerns is when they're decommissioned or abandoned, where do all these windmill parts go, or even the solar parts? I'm worried that they will end up in our landfill. I understand some of this stuff is not recyclable. So I really have some concerns about that. And how is that being addressed?
The final disposition of those materials is not addressed in the joint development agreement. We say that it has to be decommissioned in a manner consistent with and pursuant to existing state law. Whether that, if that law changes 20 years from now and says you have to dispose of the materials a certain way, we want to make sure that they dispose of them in a way that the law allows in 20 years, not now. So we address it in the JDA and say you have to decommission and dispose of the materials consistent with law.
Thank you.
Other questions? Supervisor Marash, please.
Thank you, Mr. Chair. I just want to clarify what you said with Supervisor Dickinson's question. So in the decision matrix that we just discussed, all the issues, if I'm understanding you correctly, with the 196.491, the health effects, when you have a JDA and the PSC looks at all that, if we have a JDA, then all of these concerns, they go, oh, that's fine, the county is totally fine with all these things because they went into the JDA. So is that, am I not
No,
understanding?
no, and I apologize for any confusion on that. All I'm saying is that issue 3 on that decision matrix is resolved. Issues 1, 2, and 4 through 11 still have to be addressed by the PSC.
Okay, so only issue 3.
Correct.
My other question is, who pays the attorney's fees for the JDA negotiations? If they go for 6 months, is this something that we can write into that the developer pays for all the attorney fees?
I will tell you that in the JDAs that have been executed, we have had fee shifting always. So the ones that are executed. So yes, the developer has paid those attorney's fees. That topic is being debated on a couple of JDAs right now because they've attempted to cap the fees. And I've agreed to the cap so long as the other side agrees to the same cap, and that hasn't gone over very well.
Other questions? Supervisor Gao, please, and Vice Chair Booth.
If we're looking at our process, if we want to go through a JDA and where we're sitting now, what do you anticipate would be the start time for us? Because they put their certain in notice already. So would we consider doing that as soon as possible, within a month or 2 months?
I don't know enough about the particular project timeline to know when it's appropriate. I do know about your ordinance amendment process that says when the engineering plan is filed with PSC, you have to give us notice. I think as soon as we have notice that an engineering plan is filed, that starts the time clock for submission of an application. When that engineering plan is filed, that's when we start engaging in a JDA discussion. That would be my opinion. But there's nothing stopping us from having that discussion earlier. The sooner we get started, I think the better off we are, frankly.
The reason I'm asking that question, and politics is very interesting in the state of Wisconsin. And we understand that we're going to have an election coming through, and in January, there may be different people. If we're in a process of going through a procedure of doing a JDA, and all of a sudden, some of this legislation that's been brought up occurs or be brought forth, may or may not be processed, or may not be achieved, but let's say it is. That's why I'm a little concerned of doing a JDA fairly quickly. I'm looking to see where we look at from a legislation standpoint. If we process it a little longer, would our legislation do some moves that we've been trying to do in the past legislation? And I'm saying is that, let's just strategy on that. I think is important from our point of stand, how we process it if we're going to go with the JDA. So I wanted to bring that up for a conversation, even for the whole county board and for our process of strategy, determining what may happen. Now, nothing may happen, but again, something could happen. That's why I wanted to bring it up. Thank you, Chair.
Vice Chair Booth.
So my thought process is, I guess, I believe this is a 10-person executive committee. We're supposed to make a recommendation. I think the recommendation moving forward would be to take it to the full county board, because I think there's a lot of people at the full county board that want to have their input heard. I guess I can do that in the form of a motion, if that's in order right now, but my motion would be at this point to forward to the county board, how should I state it? Discussion with possible action on a JDA. That way, the pros and cons can be discussed at the full board member, not just this committee, and everyone has their say. So that will be my motion.
Okay, Supervisor Marash with a second. So the motion is to forward to the full board the recommendation to enter into discussion with, in this case, the developer about a potential JDA. Is that accurate? I want to make sure that it's accurate with the chair or vice chair and the.
I would not say with the developer yet. I would say just with the county board, and then we would possibly, after discussion with the county board, with the developer.
All right.
Some clarity of that. I think that we should be having our say before we get the Alliant involved, is the way I'm looking at this.
So the motion is to move to the full board for discussion about the potential of a discussion on a JDA.
So it's like a two-hop, like
we'll decide if we want to even pursue a development agreement, and then later negotiations.
Correct.
I can't think of something more exciting than having this conversation with 38 people. I'm excited.
That's why I was going to do it right
Yeah.
away, but they can watch this meeting, I feel, and.
No,
at
we
least
need them
get some-
involved. I think we do.
Forward to the full board the recommendation to discuss whether to pursue a potential JDA?
Correct.
Okay.
Any discussion?
Clarify that motion, please.
So the motion is, I'll have the clerk read back the
Okay,
motion.
so
as she
what
has it.
what I put down is motion by Boots, second by Marash, to forward to the full board the recommendation to discuss whether to pursue a potential JDA.
Okay, so then the county board is going to discuss if a JDA is an option, and if we say yes, we still are not giving up other options, correct?
That is correct. Just
Okay.
saying that there'll be a discussion by the full board
Convoluted.
as to
but-
whether or not they pursue a JDA. And if the board pursues a JDA, it still is a long ways from an end agreement,
Or even a JDA at
or even
all.
a JDA,
Okay.
100%.
So let's back up a little bit in that the committee who gathered all of this information, is it not the executive committee's responsibility to act upon what the committee says? And so in this case, actually, what we're doing is just sending it to the full board to give us an option. Is it going to then come back to the executive committee? Are we bouncing around? So the committee says, here you go, county board. County board says, yeah, let's think about that. And then it comes back to the executive committee. And then we discuss whether we want to do a JDA or a moratorium or something else?
No, I think
Or
that,
then does everything reside in the full county board at that point?
I think the decision is going to be rest with the full county board as to whether or not we proceed to pursue discussions on a JDA. If their motion to move forward is to discuss a JDA, then we will enter into negotiations on a JDA. However, any result of that is still got to be come back. Right?
If I may. So our item was discussion of options, and all we did was discuss one option in this meeting. All of our conversation is about the JDA, the specifics of JDA. Counties, we've got information who have done it, advantages, disadvantages, people online, lawyers, extension, but we didn't really get in depth of the other options, which are listed in the packet. So my concern is that we're kind of leaning into a space of a JDA without really getting into the details of everything else that we possibly could be doing. I hope that makes sense. I'm feeling a little bit like we're moving into this space and I'm not comfortable moving into that space yet. Thank you.
Okay, other discussion? Other discussion? Supervisor Marash, please.
My opinion is that we have discussed the possibility of a moratorium on this, and my understanding of that is it would really go nowhere because we already have an ordinance and we can try to change it. It kicks the can down the road for a year. Not really a viable option, in my opinion. We talked about intervention. We know for a fact that all of the projects that have gone to the PSC have been approved, intervention or not. So my opinion and the reason why I seconded the motion was because I think that it's important for everybody on the county board to have a say and have their voice heard, just like we tried to allow everybody in our community to have their voice heard. And it's a very volatile topic. We all have very strong feelings about it. And I think that's why it's important to have more input from the people that are representing the constituents.
Supervisor Robinson, please.
I concur with Supervisor Marash's comments, and the Alternative Energy Task Force or Committee had a relatively short period of time and was really tasked with identifying concerns and opportunities associated with the project. And we had obviously a lot more concerns expressed, but what we do is we have a sort of an outline on if the decision is to move to a JDA, what those issues might be. But I think it's important for us to have that discussion of what we're going to do and in what sequence we do that, because the fact that Marathon County wants to move ahead with the JDA doesn't give us a JDA. It doesn't even bring Alliance to the table. We need to know that, and then we'll have to step back and say, if they're not there, or if it's not what we want or expect, we can then look at, do we intervene? But I think we need to have those discussions early in the process so we keep our options available to us should this not work.
Other discussion? Other discussion? Supervisor Dickinson, please.
So there was actual conversation here about the change to the comprehensive plan, which could lean into the moratorium issue. We did not talk about that extensively at all. It was a few comments about what this ordinance is and what potentially it's going to be and what's coming to the county board. We didn't really get in depth with it. So, I mean, most of this conversation in this meeting up to this point has been about one particular thing. Thank you.
Okay, any other further discussion? Any further discussion? All right, seeing none, we'll proceed to vote. The motion is to forward to the full board consideration on a discussion on a potential JDA discussion. Everybody clear on what they're voting on? All in favor of that motion signify by saying aye. Aye. Opposed? Aye. Motion is carried but is not unanimous, and thank you, everyone. Go ahead. Vice Chair is asked to be excused, and he has another commitment, so he'll be excused. We're down to item number 2, and I don't know that there's a need now because of the action that has been taken by the board, by the committee, that we proceed into closed session, but it is on the agenda for discussion and possible action if there's anybody that wishes to, or we can proceed on. Does anybody have any objection to moving directly to item number 5 on the agenda? All right, we will move on to item number 5 on the agenda, opportunity for arena user groups to update the committee on the respective efforts regarding the facility planning and fundraising and discussion on next steps by the committee. Administrator Leonard, please.
All right, thank you, Mr. Chair. Thank you, committee members. I know it's been a long meeting. We do have a couple of people that are here that I think would like to speak with you, but I'll just real quickly go through on page 23, there's a memorandum that outlines, again, a little bit of background on the discussion that this committee has had. Again, not an earth-shattering start to the conversation. There has been a lot of conversation about the future, the current state and the future state of what Marathon County has done for a long time, and that is operate ice arenas. So we provided an update to the committee on the feasibility study, which really wrapped in the current state of the ice arenas, and the feasibility study that was ultimately funded through a grant opportunity that Marathon County was awarded through FEMA, and that was related to a potential safe room construction consistent or concurrent with an update to those ice arenas. So that was in October of last year. December of last year, this committee met, and you talked about a decision-making process. What are the pieces of information you wanted to hear, that you needed to help make that decision? And again, what is the future of Marathon County's role relative to the delivery of ice arena services? You've heard my spiel about the budget, and You know, when I say the first policy question you need to answer is, what programs or services do we deliver? This is a non-mandated service that Marathon County, as I said before, has delivered for a great many years. The decision of whether to keep doing that or not is yours and yours alone. It's not a staff decision. It is one that rests solely with the county board. So that was the discussion in December. There is, following the memo, we included in the packet the background, again, on the ice arenas and potential decision-making framework for you to look at. Ultimately, at your meeting in December, staff were given some direction, and that direction was to go and engage the user groups again, to have a presentation to them relative to the feasibility study itself, and two, staff to convey the request of this committee, and that request was that those user groups meet, they come together, and they report back at a later date on how they view their shared facility needs and how they envision working together to support facility improvements and future usage of those arenas. We held that meeting with representatives from the user groups. I would say, from my perspective, it was a well-attended meeting. People were interested. Had a lot of discussion. I know several board members attended. It was a long meeting as well, not unlike your meeting today. But that presentation was made, and I just want to update you quickly then on some things that happened after that. We had specific conversations with representatives of the school district, and I saw Cale Bushman, the superintendent, had to step out, but there was a strong communication to county staff that the school district certainly appreciates the services that the county has delivered relative to ICE and was open to further discussion about what that would look like in the future. We have Mr. Toner, Chris Toner from the Wausau Youth Hockey. Jamie Polly and I, Director Polly and I, met with Mr. Toner as well as another representative of youth hockey at the end of April, and had, I think, a good discussion, and youth hockey was at that time evaluating what it might look like for them to pursue their own facility. That was my interpretation of that meeting. But Mr. Toner is here today to provide any additional updates to you, and perhaps have requests on what youth hockey is looking for from the county. Central Wisconsin Ice, Colin Helke is here. I was invited to a meeting that was convened by Mayor Denny, again, near the end of April. I attended that and met Mr. Helke and some other representatives of Central Wisconsin Ice. I would characterize that meeting, again, positive meeting. What I took away from that was, again, another entity was looking to perhaps pursue independent operation of a facility, different model than the current model of ICE delivery that the county runs. And it was nice to get acquainted with those individuals. After their meeting, I did present to them a fair amount of information that the county had previously been provided based on other community efforts to study and develop potential ICE arena solutions for the area. And then, as I said, the city of Wausau, we've had a couple of meetings with representatives of the city. The last thing I'll update you on from the staff side is Jamie has done a great job to continue to look for potential grant revenue to make sure we're well informed on that front. The FEMA Building Resilient Infrastructure and Communities Grant, the BRIC grant that, again, originally we applied for design. The grant was terminated. That grant, as I understand it, and I would characterize it was terminated a while ago. It was reopened. So we took the plans that that feasibility study that I referenced, and we submitted that grant to FEMA to see if we would be awarded any funds for construction. Doesn't mean we have to take them certainly doesn't mean that we're gonna get awarded them. I should have started with that. But even if awarded, it doesn't mean that the county board has to accept them. But we did want to give you that update as to the work that, again, the work that staff have been doing following that direction from this committee to hold that meeting with those ICE arena user groups. So Jamie, anything from your perspective you want to add before we have Mr. Helke and Mr. Toner? Oh, perfect. Want to grab a mic or slide over? You can slide down by Brian. Or you can take Andy Phillips's seat, the hot seat.
All right, thank you. We do have, in addition to who you've mentioned, we also have BJ Brandt here, who is kind of representing multiple hats with the Cyclones, Wausau School District. And we did have the superintendent here. He did have to step out. But I do have a statement from him too that he gave me an email if we wanted to hear that. And then we have, I don't know if Jana wants to speak, but Jana Wimmer from the Storm girls hockey is also here. So they can speak to what they've been working on as well. Oh, sure. Yeah, so I did get an email from Superintendent Bushman after our discussions with the school district about their, wanting to work with the county on a facility. But his quote here is said, "At this time, it is beneficial for the Wausau School District to continue their longstanding relationship with Marathon County. The school district believes that this relationship will provide stability and consistency moving into the future. We appreciate the relationship we have had with Marathon County for our ice hockey needs."
Okay.
Yeah, if there's anything else committee members want from staff right away, otherwise we do have those individuals that both myself
I'd
and
open up
Jamie.
to any of the individual user groups that want to present to the county. Whoever wants to go first. I won't pick out the person that wants to go first. I'll let them volunteer.
Thanks for having us tonight. My name's Chris Toner. I grew up here in Wausau, played hockey as a kid. We've had 3 kids going through hockey, and it's been a big part of our life. And so this project means a lot to us. About 12 years ago, I was involved in fundraising to expand the rink to add the additional locker rooms. And at that time, we raised about $750,000. We felt like that was a really successful project. We've seen our numbers grow quite a bit in that time. It allowed us to give dedicated locker rooms to both East and West high school programs as well as the Storm program. And so when the county presented this in March, I'd been kind of out of these kind of discussions for a long time, but got back into it and really heard about the 4 options for moving forward from the county. And one of them was to build a brand new 2-sheet facility with a big price tag. One was to renovate existing Marathon Park number 1 for another pretty significant price tag. One was to just fix what we have, and then the last one was to basically shut down the rink and not have hockey in Wausau, which for somebody like me who's spent a lifetime as a player, as a coach, that was a big eye-opener for me that was a possibility. So we formed a group that has a number of people that have begun the process of looking at what private fundraising looks like in whatever form that might be. We did have this meeting in April, and we said we're gonna move forward. We're gonna try to fundraise, but we want you to not hear rumors. We want to hear from we want you to hear it from us that this is our project. But the fact remains is that we have a long way to go, both from a public fundraising standpoint, but also from a private fundraising standpoint. BJ and I met with Jamie Polly this morning. I thought that conversation was really positive in terms of potential opportunities to get public money to assist whichever of those 4 options that they're, well, not the 4th option, but 1, 2, or 3 option that may be a possibility for raising money. Mr. Leonard talked about the BRIC grant. I think that was a positive discussion, but there's also potentially other opportunities to go outside of the county budget to raise money away from local community money as well. But when we look at this project, we're in the process of trying to evaluate what it looks like and raise private money as well. So what do we need from you? I would say there's three things. And one was, let Jamie and our group continue the discussions. I thought it was very positive today that there is potential external money that we can apply for, and see what opportunities that lends us to. Secondly, if there will be private money raised for this, we will need some time to do it, right? And so the project I referenced before, the locker room project, we raised $750,000. It took us about 1.5 years to raise that and about another 6 months to complete the project. This project that we're talking about here today is potentially quite a bit larger. We're talking about raising millions of dollars. So we are, from our perspective, we're at the absolute starting point of these types of planning and these types of discussions. So what you should take from us is we're open to having these conversations with the county, and we're committed to doing the work to make sure that hockey can continue here in Wausau. And then our last request is to keep the rinks going while we do that. We are going to need some time in order to push these processes through. If you make a federal grant request, it takes them time to fund it. If it's a state request, that will take some time as well. So we've had, on our end, we've had, I think, a lot of productive meetings, but this will take us some time. So I really appreciated the meeting this morning. I thought it was very productive, and so that's my statement. Do you guys have anything? Okay. Are there any questions I can answer?
Supervisor Arstead, please.
What is the name of your organization that you're putting together?
Sure. We are the Wausau Community Ice Center.
Supervisor Arstead, please.
One more. This one's for Jamie. When we did the upgrades, what is the timeline on that? I can't remember.
For the ice mat?
Yes.
Well, the typical lifespan of the ice mat was about 7 years, according to the manufacturer. We're taking it in and out every year. We're storing it very delicately, so we hope to make it last that long or longer. But if we were to want to replace the ice mat, it wouldn't be the price tag that it was when we initially did it, because we already have the header now purchased and all of the work done to the refrigeration room to hook it up, so it would just be the mat system itself. But 7 years is what they had told us when we purchased it.
Thank you.
Okay, other questions by the committee? Supervisor Hoppe, please.
Thank you. And how much would you have to raise before you can actually seriously begin working? I mean, do you want to, the whole thing, the whole amount, which I find would be really hard?
Yeah.
Or are you going to start at the halfway point? What are you looking to do?
Yeah, go ahead.
Well, I think, and Chris, I guess, jump in on here. I mean, I think it will depend on what option we decide. I think we have to come, we talked a lot this morning about what our next steps are, and that's kind of our question that's in the air, is we know we have 2 sheets right now. They're functional. We have an ice mat that's helping us with rink 2 because that has failed. Rink 1 is older, so we're, knock on wood, going to keep it running as long as possible, but that's why we're starting these conversations. We had presented in December of last year those 4 options to you. Ideally, in a perfect world, in my opinion, maybe I shouldn't even throw this out there, but building a brand new facility would be long-term. It would be the best long-term because of the fact that we have a 50-year-old facility that has been piecemealed over 50 years. So there's a lot of work that has to be done to that. But if we can improve one of the rinks to a year-round facility, that is what we've found during the feasibility study is the need for sure is at least a year-round sheet of ice. With DC Everest being the only one in the area that has that, there is that need. But the price tag will determine how we move forward. The first step, once we get enough money, will be to get a final design. All we've gotten to this point is a feasibility study with a concept design based on the input from all the user groups that we received through that process. And that would definitely need to be honed in and designed to be able to figure out what the final actual cost is. So there's things that probably could be done as we raise some money, but to actually go to building we want to know where all that funding has come from. I don't think the county would want to start construction without having that funding or the dedication of that funding in place.
Administrator Leonard, please.
I'll start with, yeah, that's a really bad idea to build without all the money. I'll say, Mr. Toner referenced this, where I do think, you as the board have to decide what our role is going to be. But in the interim, as Mr. Toner said, if the direction is to continue to run the rinks, which strikes me as relatively easy decision for you. But one of the big pieces that I think we tried to impress to the user groups, and I hope this came through, but as Mr. Toner referenced, the ability that the county has to leverage that outside and not even county money, to apply for that FEMA Building Resilient Infrastructure and Communities grant, to apply for funds through the State Building Commission. Again, I think the model that the county board, moved forward with our Forensic Science Center was an excellent model. It was a multi-legged stool, right? That was funded by the federal government in part, the state government in significant part, by philanthropy, and lastly by local government. We can try to continue to try to make application for those things that don't negatively impact or impact in any way the county direct budget. I know that's a concern for a number of you, but applying for the BRIC grant, we had Jamie move forward with that because you previously authorized us to do that. We can do a similar thing. We can attempt to do a similar thing with the State Building Commission. And at the same time, Mr. Toner and the rest of the dedicated people that are here can start those conversations. And as we continue to, build that coalition, at the end of the day, the decision is still yours. And if there's a gap, that decision gets harder, a gap in capital. But I do think, from the staff perspective, there are some things that are pretty easy. We'll use the poker analogy, pretty easy limp in, like, we'll throw in on that blind and see what we get. We have no idea what's going to happen with the FEMA grant. We made applications. Similarly with the State Building Commission.
Supervisor Robinson, please.
So I'm just trying to get my arms around the process, and I don't, I was heavily involved with the aquatic therapy pool. And in that case, we built the need and kept coming to the county board, and the county board said, we'll proceed if the private sector raises half of the dollars. And that was what led to the community rallying behind it. What I'm sensing is, and thank you for being here today, and I think it's great that we can explore partnerships, but is the ask of us today to make the commitment to keep the rinks open during the process first? And I think what we would want to do is define what that length of time would be, because that's not an eternity, but what would be an adequate period of time. And then we would continue to explore the options of what are the levels of commitment in those discussions relative to the ongoing fundraising efforts in order to pay for it. But I'm in a position where I'm willing to make a commitment to trying to keep those rinks open for a period of time certain, but is that now 6 years? Because we had 1 year under the mat? What is the time frame? And it can't be 6 years because we don't take the mats out and then have a new arena. So is it 3 years? Is it 2 years? And so I'm trying to build, what is a realistic schedule for us to engage in these with milestones as we move forward? And perhaps what we need to do is have another meeting, and the issues is, are we committed to maintaining this during that process? And what is the time frame for us to make the decision on moving to the next, and to allow you to do that work with the community? So are we in a position today to be I appreciate and understand the 3 points that you've raised, and I think that's reasonable from asking us. But then we have to in turn figure out what's reasonable and what timeframes are acceptable to the board.
Yeah, I think that's a great question. I think about the locker room project we did, and the first thing we got was private foundation money. So that was the first money in. Then from there, we raised about $200,000 of just private money. We'd go around to a bank and they'd give us $10,000. And so that grassroots kind of work. And then we went to the city of Wausau and asked them for $75,000 of room tax dollars. And they gave us that, and that got us above $500,000. And once we got to that level, then all sorts of money came in. So that's what got us to the finish line, was that one, it was 10% of the value of the project. I think you have to think about this in a similar kind of way. So as we're building our bricks here, one is the FEMA grant application. When does that come in? When do we hear about that? Any other public-based grant applications that you make, you got to figure out when they're due, when we're going to find out what's the funding schedule. Are there opportunities for us as a nonprofit organization to go do the same thing? Okay, well, we can do all of those things. So I think we can build a timeline, but all of these things have to happen within a certain period of time. And so we got to hit all the buckets and be successful at the majority of them to raise the kind of money we're talking about. So I think we can work on a timeline and maybe report back on that, because I think it's going to be a very specific, there are going to be specific asks, but there's also going to be specific responses that we get. You either got the grant or you didn't. Okay, well then what's our backup plan? So I don't have a great answer on that, but I think we can talk about what a process looks like and what is reasonable if all of those things come together.
Lance?
Sure, thank you. I think that's a great idea, and I think your analogy, again, to go back to the warm water therapy pool process is a sound one. I'm not saying it's perfect, but it's the best analogous situation we have. And you started your comments, Committee Chair Robinson, with how long can we run the ice arena? And that's like asking me, how long is my Prius gonna run? It's got 336,000 miles on it, which is about the same as our ice arena. It depends. We have, the MAT system is a good thing, and Jamie and her team, if you have nothing better to do, it's really interesting to see the header system and how that all works. It's great. But we also didn't fund the cooling tower replacement when that went through. I mean, if any one of these things goes, you, the board, are gonna have to make some decisions about how do we fund it. But I think all that aside, we will, absent direction otherwise, staff are gonna keep doing what we're doing, working well with the user groups to manage and program the ice, while I think Mr. Toner's comment about putting together that plan is absolutely critical. And it's been my experience with a similar one with seeking those funds, going back to the Forensic Science Center. It was really important to get that, a couple big donors to start. And then you'll have, for example, we know the building commission, we can't say how much you would get or if you'd get any, but your amount you can get is capped. It's gotta be, can't be more than 50% of the overall project. The remaining 50% has to come from other sources, including local match. Now, that local match can include federal dollars, which your FEMA Building Resilient Infrastructure and Communities would cover. Similarly, Mr. Toner's comment about room tax dollars is a great reference, because Jamie has told you before about other models in other communities where room tax dollars are used for those things. And I had a conversation just this week with a staff from a local municipality that thought that was a great idea, that it does bring in, depending on how you program it, it certainly can be different, but it does have the opportunity to bring in those room tax dollars. So all good conversations to have, but they are gonna take time. This is you're trying, in my again, my analogy, you have to try to thread the needle. It can't be, oh, we have 7 years to raise money, because that's not enough of an emergency to do it. And at the same time, you can't say you have 60 days to go do it, because it's too much money to raise in 60 days. You got to try to find what is that sweet spot of timing. And very candidly, I think, and it's great to see all the user groups here, I don't know that there's enough resources in our community to have people not working together. If you take and you divert efforts and people are trying to raise money for similar things from the same limited pots, I don't know that we'll be successful, but it's great to see that there are people here that are interested. But I do think from the staff side, if you're looking for my assessment, again, I think the opportunity that we have from the staff energy to at least be looking for those grant opportunities and continue to do that. Jamie already submitted the FEMA grant. We can look for the State Building Commission, assist with the timing, because again, you're going to do that in accordance with the timing for the release of those programs through the state.
Okay, other questions? Supervisor Rosenberg, please.
Sure, I have kind of two comments and maybe questions here. So the first one is, I love that we're applying for the BRIC grant. And there are other communities who are getting grants that aren't BRIC to build resilience into some of these things. I visit with these communities every day. That's part of what I do for my day job. And they are getting grants from other organizations. So if you're interested, I can send you more resilience kind of opportunities, because I think that's a really big deal, especially if the power goes out and people need to refrigerate medication or charge their cell phones or whatever. I think it's a really great community effort. But also related, as Marathon County kind of approaches this 50% ALICE population, I wonder what the opportunities are for maybe the underserved kids, because we know sports are so good for kids. They keep them out of trouble, and they build habits that are good for healthy living. Are there opportunities with these organizations for scholarships for the underserved in our community, so that as we talk about using public dollars for something like this, we also know that we're giving opportunity where maybe they wouldn't have it otherwise, and they can avail themselves of this public resource?
Yeah, that's a great question. So one of our members is a guy named Don Bradford, and Don has been integral in youth hockey, not only in Wausau, but in the state of Wisconsin. And one of the things that Don has done every year for as long as I can remember is get donations to fund paying for all of the hockey equipment for kids that are starting out. And he does the Try Hockey for Free program. And he's on the statewide hockey board. I'm on that board with him. And he goes statewide and gets like 200 bags of free hockey gear that associations hand out to brand new members. So when you come to us, your first year, you get all of your gear. You don't pay anything for the first year. And we're reaching out as much as possible to anybody that wants to play. So that's number one, is there an entry point for people that are underserved? Absolutely there is. Number two is, if you get in our program, we have a pretty robust scholarship program where if you need fees deferred, we have an application process, and it's very well funded. I think we grant every single request that we get. My hockey coach as a kid, when he passed away, the donation, the thing that they said at the funeral was, don't bring flowers, donate to this, so that money can be used to pay for kids that are underserved to come and be able to play. So cost should not be a barrier to playing our game. We've got a lot of structure in place to make sure that that's true. And we've seen kids really benefit from it, because you're exactly right. It's a place to belong. That's why we're here, because we got that opportunity as kids, and we want to make sure that everybody has that same chance.
Thank you.
Supervisor, go ahead, please.
Thank you, Mr. Chair. I think one other piece of the puzzle that we really need to know, and we're going to need some input from the end user groups, is what do we actually need? I mean, I would love a great big new building on my property, but I don't need it. And it would be fiscally irresponsible of me to build it and hope my neighbors can help me pay for it.
Right.
Right? So we need to know what you feel is what you actually need instead of what you want. I can tell you for my district, the people that I represent, they're already telling me they feel like the county is nickel and diming them. For me to go tell them, hey, we're building a great big brand new ice arena and you're gonna help pay for it, it will not go over well.
Right.
So that's just my input.
Sure, no, that's a great question. So we currently have 2 sheets of ice. We maximize the use of that all the time, and if you asked our program, we could use more. Everest's program is, they have 1 sheet of ice, they could use another sheet of ice. So what could we handle is maybe the way I'll start that answer is what could we handle? We could easily handle 3 new sheets of ice. What do we need? 2 sheets would keep us where we're at, and we're full. So the opportunity here is to have summer ice. We don't have that now. That would open up a lot of doors, and when we go try to rent ice at Greenheck, we're basically unable to do so. We get an hour here or there, but they're pretty much full over there. So 2 would get us to where we're at now, and we would use that to its fullest capacity.
So I guess if I could add, then I think that would be a good metric for you to look at on how much money you need to raise. In your group. I would say take the time you need to raise it, but I think a lot of the burden's gonna have to come on the end user to pay for all of this.
Yeah, and, you know, I gave you the example of how we funded the locker rooms on purpose, right? First money was private money. If we have FEMA money, that's awesome. That's not coming from anybody out of your voters' taxes. Are there other public grants that we can get? So all of the external money that we can get first that's priority number 1. So that's how we're thinking about it.
Other discussion? All right, thank you so very much.
Great, thank you.
We will move on then to the agenda. Item number 6, the discussion regarding the 2027 annual budget development and policy recommendations from the committee, including review of mandatory discretionary. Oh, excuse me. I mean, if there's other, I apologize to the other individuals that came and waited so patiently, and I didn't mean to move on, but is there anybody else that wants to address the committee on this topic first? Please, by all means, it is totally, and totally I apologize for moving on without, if there's anything that you want to bring up as far as importance that this committee should be understanding as far as the process that you're looking at and the timeline that you're looking at. All right, is it Supervisor Robinson?
Could I ask that we try to set a timeline for that next conversation, and could that be within 2 months?
Yep. Very good, very good.
Can I just ask one clarifying question? So I think one of the, and I don't know at what point, I guess I'm just asking this, and maybe I should not ask this during the meeting, but, you know, Chair Robinson brought up, and the warm water therapy pool has been brought up a few times about if the county's willing to help support it at all, and I know we don't know what that amount is, so maybe that's whatever that gap funding might be. But I think in my conversations with the groups too, if there was any type of idea what might come, you know, from the county board, whether it's through our capital dollars that we need to put into our CIP or whatever. I don't know when that discussion might have, I guess some advice or some input for them, because that's gonna be part of our discussion when we sit down, is where that comes from or what that looks like.
I think we'll develop that timeline and when we'll have those discussions at the full board and potentially at this committee with a recommendation to the full board in the next 2 months.
Okay, so it'll come with our discussions on kind of timeline working backwards, what funding options might be.
Right, correct.
Okay.
All right, anything else on that topic? And again, I apologize and I appreciate everybody's willingness to stick around for this very lengthy meeting. All right, with that, we will then now move on to item number 6, a discussion regarding the 2027 annual budget development and policy recommendations from the committee, including review of mandatory discretionary program documents and discussion on rates and fees. Okay, sure. We have with us individuals from the Advanced Wisconsin. So is there any objection to taking number 6A out of order on the agenda? All right, so I appreciate again your willingness to stick around. And so I would invite individuals from the Advanced Wisconsin Employment Life Work Program to come up and present to the committee their presentations.
You're all set and just scroll with the mouse.
Okay, thank you. Thank you. We'll make this really quick, everybody. So, hi, my name is Libby Heidman. I'm the Workforce Services Director with Advanced Wisconsin Employment. Advanced Wisconsin Employment is the Workforce Services Board for the North Central Wisconsin area. We were formerly called the North Central Wisconsin Workforce Development Board, which got a little lengthy, so we shortened our name. And we are here today to talk about a program that we are starting called LifeWorks. And to not bury the lead here, we are presenting this information because we would like to present to the full board at some point to request some funding for LifeWorks. But today what we want to do is talk a bit about the program itself. Amy and Rob are here. They're going to be the facilitators for the actual curriculum and classroom experience. And then we'll answer any questions that you might have. So first of all, many of you all know this, is that we do have a workforce shortage in Marathon County. Most of the jobs in Marathon County are in manufacturing, and we do have a relatively low unemployment rate, but our participation in the labor force has been going down significantly since the year 2000, and we are getting older. We do know that as well. So the participants who are in the workforce, the numbers are smaller, and we're not having as many people to grab to have going into the jobs that we have open. Are we on slide 1 or 2? And so one thing that I wanted to talk a little bit about was how a workforce board is organized, because it is a little bit different than what most people would expect. We are not a state entity. We're actually a 501c3, but we do have oversight from elected county officials. So Supervisor Morash is actually the representative for Marathon County, who is part of the 9 different supervisors who have oversight over our board. We have a board of employers and other entities that 51% have to be employers. So while we're a 501c3, we have county oversight, and we also have businesses that are part of our operating board. So for us, we're an interesting public partner entity, and we're considered a pass-through entity, and that's how we can get federal and state grants. So we do have local oversight over the federal and state money that we get and how we can implement that into the workforce needs for our area. We also do oversight of our local job center. So we're one of the partners in the job center that's in Marathon County that just moved to 11 Scott Street. And we do have a number of different employers that we have partnered with explicitly for this program, including Shooty Metals, Wausau Tile, Greenheck, Crystal Finishing, and then for a different portion of the program, North Central Healthcare. Another reason why we're deciding to do this particular program is because while we get a majority of our funding through the Federal Workforce Innovation and Opportunities Act, that funding has been significantly reduced since the year 2021 by about 40%. So the dollars that we have been receiving to help people get jobs in our area has gone down significantly. And just to show you kind of a breakdown, we have different programs in our youth, adult, and dislocated worker. And so over the past 5 years, this has been kind of the decline in our program funding that has come from the federal government. And so because we are a 501c3, we want to utilize that opportunity that we have to get different sorts of funding mechanisms in place so that we can keep offering opportunities to people to get training for jobs in our area that are specific to the needs of our local workforce. And so a little bit about the program, and I don't know if Amy or Rob, you want to kind of hop in and talk a little bit more about just what it looks like.
All right.
You can just hit the button and then you'll be good there too.
Okay. All right, so just a brief overview. We do have some copies for you here. With the population that we are serving with this pilot program starting next Monday would be 6 justice-involved individuals that were referred over by their probation officers. What we're seeing, since Libby had mentioned that our unemployment rate is so low, we are still struggling for those folks that either A, have justice involvement, or B, are folks with disabilities. So our first pilot is going to involve those justice-involved folks. We've redesigned this curriculum from a past LifeWorks training that we did just for youth with disabilities. And we're just covering the basics that sometimes weren't always taught. We're finding the motivation to work. We are looking at past separation from employment, reasons that they haven't been successful at maintaining employment. We look at some of those areas that they might need support in. Right away on day one, transportation, housing, we get them connected to local area resources in the community and help them try to start solving some of those barriers right away at the beginning of this 3-week training. We go into what are the employer expectations? What does it look like to be a good employee? How do you read the employee handbook? What are the attendance policies? Getting to those basics, problem solving, teamwork. We also look at doing some career assessments, getting to find out maybe they just weren't in the right career path, helping them to identify those skills and interests and get them connected to local labor market information. These 6 folks have identified manufacturing is their industry, and these employers are buying in, hoping that once these 3 folks or 6 folks get through the 3-week training program, that they will have successful employment. They have guaranteed interviews. They will get through without missing any days, and they'll be able to take a chance at having a long-term employee. We also help them to develop application, their resume, cover letters. We work with them extensively on some interviewing, and then we also do tours of these employers. So that's a little bit. It is 2 weeks of soft skills, but then we're also partnering with NTC's Move to Manufacturing training program. So they will be doing some 8 hours of online basics of safety, as well as 1 week of in-house at NTC hands-on hard skills training. So that's the program in a nutshell, and Rob has handed a little bit of that breakdown on all of the things that we cover with this training. Do you have any questions on the training in general? I'll let Libby get back to the details.
Supervisor Arstead with a question?
Not so much the training, but you talked about justice-involved adults and youth with disabilities, and additional populations. Do you would you be bringing in the unhoused, those that are living on the streets?
Yes, actually, there are, I believe, 2 folks that are currently homeless that will be attending this training starting on Monday.
Wonderful, thank you.
I guess the question I have, I mean, so the 2-week program, and I support the program, the skills that are needed in some cases are lacking in some of the individuals that are challenged. So the question is, the 6 individuals that you're the first cohort, if you will, going through this, are they all from within the county, the multi-county region, or exclusively Marathon County?
We do have 4 folks that are in Marathon County, 2 that are in Lincoln County that would like to work in Marathon County.
Okay, all right, okay, perfect, thank you. Other questions? Let me please.
Sure. So we're going to start with our Justice Involved, and then we're going to be moving on to adults and youth with disabilities. We do have some planning in place with an after-school pilot with DC Everest, so it would be students who are going to be nearing graduation, who have disabilities, and working with them in after-school program. And then, there's been a number of additional populations that we've discussed. Supervisor Rosenberg just brought up ALICE populations. Having individuals who are underemployed could be another population who could potentially fit into a model where there could be some upskilling that we could fit into. One of the things that we really look at is what are the services that we are already tied to, and being a partner with the job center is one of those strengths that we have, because if somebody does need more supportive services that we can offer in a training like this, we can get them connected to one of the WIOA programs at the job center, or maybe with the Veterans Service Employment Rep there, or with somebody who works with Job Corps, or another one of those programs. I know Amy and Rob have worked with this population for a long time, and they know how to get people connected to what they need. And so I think that having that connection already and us living in this space can help with these individuals, getting them connected if they need it, with a little bit more of that support. But for some of these people, they may not need that level of intensive supportive services and training. But yeah, the additional populations has a lot of potential, I think, and that's partially why we're looking at some of these alternate funding models as well, as to what kind of populations can we support with that kind of funding. And so this is just a little bit more of that, kind of the model and how the weeks are broken up. So we went over that. Again, just kind of more of the topics and the things that are covered. Some of these may, depending on the population, like some people have more computer digital literacy than others, some may not. So that's going to definitely change and vary. And that's the great thing. Amy designed this program so she can change it to fit the needs of the population. Teenagers may be different than people in their 30s. They may be different up in Vilas County if we get up that far. Right now we're focused in Marathon County, but we have hopes that eventually we'll be able to get this to our 9-county region with having connections with each of the different counties.
Can I just ask a question?
Go ahead.
Yeah, sorry, I'm just going to interrupt then. I'm curious, you talked about some of the partners you already have, especially in the employment spaces and the job center and stuff like that. I'm wondering, obviously some of these folks, especially if they're justice involved, they have conditions of their parole, but maybe there are other people who just are struggling with other things, mental health services, whatever. Do you have a process for maybe referring people to maybe services that Marathon County offers, for instance? I'm thinking that could help them more, or that they already qualify for. Is that something maybe that would be good for us to work together on, just to create this bigger project for all of us, apparently, is where my head is going.
Yeah, and I don't know if Amy, if you want to talk about how when you've worked with participants in the past, like how you've gotten them connected with services, or even Rob, because I know that you've worked with this population.
Yes, part of that first day, like I said, is identifying the needs. We do have a worksheet called the Life Area Survey where they can prioritize. I think there might be 15 different life areas that they can rate, mental health being one of them, substance use, transportation, housing, and they look at that survey and they can self-identify. Maybe they are homeless, but maybe that's not a priority area for them. So we have them complete that, determine what that need is, and then we also have a challenges and solutions worksheet that we go over where, okay, if transportation is the number one barrier, how are you going to get to an employer? What is your plan A, B, and C? Rob and I are going to utilize the ADRC resource manual and connect them, identify what resources are available, get them connected with other organizations such as Food Share Employment and Training that may be able to provide that. They are working also with their CSEP coordinator in probation and parole, who also has some availability of gas cards. So we do look at that holistic need and, refer them to resources as needed.
That's great, thank you.
So I guess the other question I had, is, you mentioned the first cohort's going to have 6 participants. What is the capacity of the program? And I'm assuming we're looking at trying to replicate it every 2 weeks or every 3 weeks or 4 weeks. Is there a timeline? And because that's going to obviously result in the need to discuss for additional funding potential.
I think with this being a small cohort off the bat, I have not been a part of the other LifeWorks training program that they had done previously with the youth with disabilities. But I think if we have a large enough space, we could expand this even bigger and just have additional staff support to do those one-on-one needs. I think at this point, our intent is to run it next week for the justice involved folks, and then as well in October for the youth with disabilities as an after-school program, and then it's going to be as funding allows. We do have grant funding that we currently operate through federal and state funds, and with some of those grants, we are going to be implementing this as an employment model that folks have to go through utilizing those grant funds. We are hoping to partner up with DBR and see how often they would be willing to fund this for their participants. However, when it comes to bringing in outside populations, I think that's where our ask comes in, is determining, do we have enough of a budget to offer this more in the jail system perhaps, or in general public, in addition to what we're using with our current grant funds.
Thank you. And I'm assuming then you'll be also measuring success rates and reporting out on those.
Yes, correct. We will have a follow-up period. We will have release of informations with their probation officers as well as with the employers so that we can track
Sure.
follow-up and still offer some of those retention services with the individuals.
Thank you.
One other aspect that hasn't been touched on yet is we're trying to get this into some of the drug courts, Wood, Portage, Marathon County drug courts, as part of their phase 1 to get people acclimated back into society. Employment is a great read on recidivism. So that's one of the main goals is getting people out, keeping people out with employment and giving them a new pathway forward. So I just wanted to mention the drug court aspect that we're working on.
And so with the funding part, we do want to, like I said, come back to the full board to ask for funding. We don't have a particular amount, obviously, in mind right now. We want to get through these first cohorts. We want to have a clear picture of what it costs to run, what it takes to run it, how many people it would take to do this on a consistent level, that sort of a thing. Right now, I'm going to skip a slide here because it's just repetitive. We do have funding from the Community Foundation, Greenheck Foundation, Associated Bank, and Wood Trust Bank. That image there is not actually very representative of the actual money that we have. It was an image that I created, and then we got info that we got the Greenheck grant, and then I couldn't change the image because I can't do graphics. But it's just part of that funding model. WIOA has shown us that with getting that federal money, we can't put all of our eggs in one basket. And so with any other program that we want to explore, we want to make sure that we're doing it in a way that's using a lot of different funding sources. This could change tonight, tomorrow. Like, I have 2 more grant applications that have been applied for. I'm just waiting to hear back on. We've talked with United Way, and they said that we have a strong case to apply for some of their funding, but that funding wouldn't be available to apply for until 2027, with the money coming in 2028. So we have to kind of, like the previous group said, there's a lot of funding and timing that we have to take into consideration, but we are looking into any of the federal grants that we might apply for. How can we work this model in? If there's any state funding that we're doing, how can we work this model in? If there's private funding, we're also looking at sponsorship levels with our employers that participate in this program, if that's something that they would be interested in, to be a premier employer, to potentially, purchase a van so we can get people back and forth, that sort of thing. But we do already have some funding that we are using to get the startup costs going. And so that's kind of where we're at right now. And our boss is not here, but I'm going to put his contact information up for you all to contact if you have questions. But really, that's what we wanted to bring this to this committee to see if, one, the committees that you all represent, if that committee would want to hear this information. And if so, we would love to come and present. If not, if we came to the board, what information would we need to bring, or what would you want? And how would we do that?
Thank you.
Supervisor Rosenberg first, and then Supervisor Robinson next.
Okay, I'm going to leave the big questions for maybe our board chair to answer. But one of the things I think would be really great, you mentioned in one of your previous slides, you talked about community priorities, and I'm sure you have ways of identifying that. But one way that we have identified community priorities for the county is our strategic plan. And of course, we want to be the safest, healthiest, most prosperous. And so when I think about programs that we might want to fund, I think it would be really beneficial for your organization to kind of look at what that means. And I'm sure you'll find some alignment there. And when we talk about it in that way, the board also knows how to talk about it in that way. So I think that'd be really great.
Supervisor Robinson, please.
I would just make the request that we follow the normal process by which we would bring these requests, and that would start with the Extension Education Economic Development Committee, Supervisor Morash, then go to the Human Resources, Finance, and Property, and then to the board. So if you could just tie into our process, I think that would be beneficial to you.
And what was that order again, one more time?
So it's the Triple EDC Committee, Extension Education Economic Development Committee, and depending on their recommendations would then potentially go to the HR Finance and Property Committee before it would ever go to the full board. Supervisor, please.
Thank you. Thank you so much for the presentation, former educator, and this is just like my bag of chips. I do just have some questions though, especially regarding this funding. I've never seen, you guys come for funding before, and I'm just curious if that's because of different cuts at the federal level, and now you're finding gaps that need to be filled. I'm seeing head nods, which just makes me think this is a canary in the coal mine. We're going to see more and more entities that have never come for funding come our way. I'm seeing it at the county level with, extra positions being sent to social services. It sounded like our nursing home is increasing charity care. I work with the United Way a little bit, and they are getting lots and lots of requests, way more than money that they have coming forward. And it just, it makes my heart ache for that. And so this doesn't sound like a temporary thing. This sounds like a structural, like this is going to be ongoing.
Sort of, and potentially. I think, so the Workforce Innovation and Opportunity Act was enacted in 2014, and its statutory authorization ran through 2020. And then since then, it hasn't been reauthorized. And it's been kind of floating in limbo and has been, funded through appropriation bills every year since then. But it has just kind of stayed in this space. And I think from our standpoint, we can't just sit and wait for something to happen. If we want to keep offering the services that we want to keep offering people to find jobs, we just need to relook at how we're doing things. And this is our step in doing that. So we have the flexibility to do it. We just haven't really flexed it very hard in the past. And that's one reason why we're here. Go ahead.
I'm sorry, I don't remember your name. Yes.
Mike Ritter.
Supervisor Ritter, earlier in the day, you asked, what do you need and what do you want? What kind of house do you need? Would you like to have a new house? It's not fiscally responsible. What we're doing here is we're maintaining what we're already doing for populations that need our services. We're not building anything new. We are maintaining what we've been doing for years. I've had the privilege of working for the board, Advanced Wisconsin Employment, for 8 years. Before that, I was a jailer for 30 years. and seeing the justice-involved individuals and some of the barriers that they have is detrimental to us as law-abiding citizens on the outside if we don't get them on the right road and help them just a little bit. So we're maintaining, we're doing what we've been doing. We're not building a new house. We're not asking for a huge mansion. We're just trying to keep the same two-family bungalow so that we can continue to service people within our community. It's a roundabout way of giving you a good explanation of what we're trying to do with LifeWorks.
Okay, thank you. Anything else? Anything else, Libby? Any other questions by the committee? All right, so again, the process would be, reaching out to Chair Marash. She chairs the EEEDC committee, also sits obviously on the board. And so, getting it on her agenda, and then the discussion on the ask at the committee level, and then potentially, depending on their reference, would be referred to HR Finance and then potentially to the full board.
Yeah, thank you. Thank you, everyone.
Thank you. All right, now, does everybody need a 2-minute break, or are the last two items let's just try to get it wrapped up?
I like it.
All right, we'll try to get it wrapped up. Move on to number 6, discussion regarding the 2027 annual budget development policy recommendations from the committee, including reviewing mandatory discretionary program documents and discussions of rates and fees. Each one of you, as the chair of each of your standing committees, have seen this on your agenda. It's reoccurring. I'll turn it over to the administrator for a quick synopsis of where we're at.
Ditto. I'm not going to say anything. I want to just talk about the new position request. So if we can jump to that one, we're good.
We'll move on then to item number 7, update on a potential consideration of new position requests and/or reclassifications in connection with development of the 2027 annual budget.
Okay, so again, all of you have had committee meetings where this has been on the agenda. The process is not new. Staff, departments that have a new position request, consistent with the direction that you gave through the poker chip exercise. I've evaluated those with my HR director, finance director to cost them. The direction, not providing new positions that require additional levy beyond the budgeted compensation increases, so no new money coming in. And that's what we did, taking them to each of the standing committees of jurisdiction. If I approve them for your consideration, they went to all of the standing committees. Those that were approved at the standing committee level went to HR Finance and Property. HR Finance and Property, consistent with your direction, made a motion yesterday to build them into the budget with one contingency. This is, you meet after them. So this is, I report to you, my department comes here, you're the oversight committee. I'm asking for a reclass of a position, and the important thing with reclasses, it's when the job has already changed. This work is being done in connection with changes you made in 2024. My office was given a significant amount, all oversight, in fact, for the foreclosure process in your ordinance. That has largely been vested within my office in what had been a senior administrative assistant position. It still is. Those changes are significant. We've looked at that, and it's appropriate to reclass that position. From my perspective, it's a very slight cost. I can handle it in my budget without any new levy coming in. So HR Finance and Property approved in putting this position along with all the others in the budget. This position, of course, is contingent on your approval here.
Discussion. Supervisor Robinson, please.
I would move to approve and recommend the reclass of the senior administrative assistant to the office manager.
Seconded by Supervisor Arstead. Any discussion on the motion? Motion is to approve the reclass for the administrator, in the administrator's budget, in the administrator's position. Not the administrator's position, the administrator's assistant position.
We ain't gonna reclass him down that far.
I'll amend the motion.
Any further discussion? All right. Seeing none, all those in favor of that motion signify by saying aye. Aye. Opposed? Motion carried and is unanimous. Thank you. We are now down to item number 7, next meeting. Committee members are asked to bring ideas for future discussion. Next meeting is scheduled for September 17th at 3 p.m. This room, I will take number 8. Supervisor Rosenberg, Supervisor Robinson with the second to adjourn. All those in favor of adjournment signify by saying aye. Aye. Opposed? We stand adjourned. Thank you, ladies and gentlemen.